Hi, everyone. I'm going to start early just so I can chat with you. So, people on replay crew can know to fast forward. I just want to yap at you for the next 10 minutes until people trickle in, and then we'll get going. I think a lot of people weren't expecting this stream to start till 11, so we'll just talk. Hi, is it Bina or Bina? I'm sorry if I mispronounce your name. Good morning, Margaret. Katrina's talking about how she has to work 12-hour shifts. Yikes. Good morning, Joan. Oh, from Massachusetts. I never pronounced that right. Hi, Diana. Hey, Courtney. Nice to see you here today. We were talking about yesterday, we were talking about the way the detective demonstrated how Courtney threw the knife. And I kind of wished you were here because you might have had something to say. Hey, Kim. It's nice to have you here. Bina, thank you for telling me the pronunciation. Hi, Tiffany. Oh, from the UK. Good morning, Ada. Colorado. Oh, it's snowing there, eh? I'm up in Canada. We don't have snow here yet. Courtney says, I watched the knife video, so many thoughts. I haven't seen it. Andy, it's birthday celebration day today. 249th birthday of USMC. How's Watson? Watson. Watson's calm now. She we went out this morning to do some stuff and we talked to a stranger. Well, I talked to a stranger, and she was really great. Sat beside me, just waited. And this poor guy, he wasn't doing anything wrong. All he did was take one step toward me. He was like 5 feet away. He took one step forward, and Watson went bananas. Scared the crap out of the poor guy. So no one can have a conversation with me. I guess I belong to Watson. So she's probably tired from all that. Hi, Nikki from Wales. Is it raining, Nikki, where you are? I joke, it's always raining over there. Katrina says that's Watson's job. I guess so. Her job really is to find things. Sometimes I hide my keys and get her to find them. Diana's asking Andy if he's going to the Marine Corps ball. Sarah says, we have a dry day in the UK today. Haha, getting cold now. You guys don't get the same level of cold as we do. Joan says, in a previous comment, I misgendered Watson. Watson doesn't care. Watson's just Watson. She doesn't care, and neither do I, so it's okay. Kim says, my Chihuahua Pomeranian cross does the same. Less impressive, though. Why is it less impressive? I don't know. There's a guy who does dog videos, like when God makes dogs kind of thing, or when robbers come in and meet different kind of dogs. I don't know if I'm explaining this right, but he imitates the dog and it's hilarious. And he has this thing about chihuahuas about how they're crazy. Oh, yes, Andy. Courtney's pointing out tomorrow's Veterans Day. And happy Veterans Day. 69 degrees down in Alabama, Zuzu. What is that? What is that here? That's about 20 Celsius here, I think. Hi, Roz from Cambodia. Sarah, I'm in Canada, yeah. Nice. We're 4 minutes away from starting the video. Oh, Kim, you watched that guy on the internet? He's hilarious, isn't he? I think he's Canadian too. Katrina, you have a Chihuahua mix. She's the sweetest. Never met a stranger. Really? Hi, Bender. Sarah, I will stay warm this winter. We up here in Canada, we know how to dress for winter. And Watson loves the snow. So I don't have an excuse not to go outside. Kim is talking about the guy on the internet who imitates the dogs, and she's saying his stares with the chihuahuas and laughing. Yeah. Yeah, he's got like this evil stare. It's hilarious. Courtney is talking to Andy in the chat saying, I know I've said it before, but we're grateful for your sacrifice. My brother was an Army veteran, early 90s. He's passed. Oh, sorry to hear that. So I feel connected when I meet other servicemen and women. Yeah. My, yes, Andy, thank you for your sacrifice. My grandmother during World War II joined the army when women didn't do such things. And my great grandmother was so mortified, she threw all her clothes on the front lawn. Good morning, Addie. Okay, I think it's 10:58. I think we should probably get started. As usual, if the sound is not great, let me know. And what I mean by whoops. Oh no. So I totally messed that up. So I guess we're not getting started for a second. What I mean by if the sound's not great is if my mic is significantly louder. Shoot. If my mic is significantly louder the than the video, then I need you to tell me. So sorry. I'm just looking for my spot here. I messed up.
More than 5, less than 10. Vote.
Okay. So just so you know, the sound quality and the video quality on this video is really bad. It's not your internet. It freezes, it gets blurry, the sound cuts in and out. And then there are times when it's better. So hopefully it's not too terrible. If it is too awful to watch, let me know, because we don't have to watch the whole thing. There's no law saying we have to. So I think I've got the right spot where we left off. If not, then I'll fast forward. Hey, Safety First, thank you for joining us. All right. Here we go.
3 or 4 times.
And what did you tell her every time that she was asking about how he's doing?
That he was just at the hospital and they're still working on him.
And so that's not the truth. That was a lie, correct?
Correct.
Now, you've produced a report in this case, correct? I think it's abbreviated 310 or 301.
Yes.
And what kind of report is that?
That's just a brief report on the investigation.
Okay. And so you have not prepared a final homicide report then, correct?
A supplement? No.
No. And are you working on that?
Yes.
And when will that be available for disclosure?
Objection, Roland.
When I, hopefully soon.
Okay. And the contents of that report are going to be consistent with what you're saying here today, correct?
Yes.
And there's not going to be anything added or anything different, correct?
No.
I wonder why, if he knows what's going to be in the report, I wonder why it's not done. Very interesting.
Prior to conducting the interview with Ms. Clenney, did you conduct any background investigation, speak to any other potential witnesses or anything like that prior to conducting her interview?
No.
Did you arrive at the apartment? Was that
Yes.
your initial arrival point, I believe?
Yes.
Okay. So were you able to view the condition of the apartment at that time, or did you go back later?
I briefly looked at the apartment, the condition first, and then I went back later on and looked at it again.
Okay. And did you speak to any of the first responding officers prior to conducting your interview with Ms. Clenney?
Very shortly.
Did they mention to you that she was in a state of panic at the time
Yes.
when they first showed up?
Yes.
She was covered in blood, right?
Yes.
Which was consistent with, I think, what you said you reviewed some body-worn camera. That would be consistent with her cradling Ms. Baselli in the living room area, correct?
Yes.
And did the other responding officers? Well, let me ask you this: what was her mental state at the time that you first spoke to her?
When I spoke to her, she was more calm than when she was at the building. But she was still a bit shaken up due to what occurred.
Which that would be kind of a normal human reaction, right?
Yes.
Now, also, I believe in the body-worn camera. Let me ask you: have you reviewed all the body-worn camera of all the responding officers that evening?
Not all of them. Most.
Okay. And a lot of them, Courtney's expressing her concern for Christian, right?
Yes.
And she's in a state of panic. What would you call it? Okay. Again, and her dogs are running around the apartment barking. It's a very hectic scene, right?
Yes.
Most of the scenes like that are chaotic. There is lots going on. There is a lot for detectives to do, a lot to look at. I find it a little weird that we're at this stage where there's a bond hearing and he has not yet reviewed all of the body-worn camera. And again, I'm wondering why. Katrina in the chat is saying normal human reaction, except she's always dialed to 10. Yes, Kim is saying her concerns could also be self-serving. Could be. When at scenes, people who are normally stable and reasonable will act out of this world at a scene like that. So it isn't surprising. I mean, not everybody reacts like that, but it is really common. The thing that really betrayed that she has a pattern of behavior was what we saw when she was in the interrogation room. That, I think, is more telling in respect to how she normally is. AKA Shaza says she was not helping with the noise levels. True. I've been to calls where people will just scream, no words, scream and run around in circles. People react in all sorts of ways. Some people react in anger. I have a story. I went and had to do a death notification, and I mean, the person wasn't a suspect, had nothing to do with it, was an accident, everything else, but the guy got violent and we were suddenly at risk. So really, people really react very differently.
Now, you heard or you saw, I think when you were testifying in direct, a clip of part of Miss Clenney's statement, correct?
Yes.
And she describes the attack on her by Mr. Marcelli, correct?
Yes.
There's nobody else in that apartment at the time, correct?
Correct.
There's absolutely no eyewitnesses to what occurred in the apartment on April 3rd, 22, correct?
Correct.
No eyewitnesses. Yeah. Because the one witness, the most important witness, is deceased.
So your investigation, it focuses around what happened after, basically, right?
Yeah.
Now, the part of the interview that we saw, that was actually the third time that you asked her to kind of recount her. And the first time, do you recall what she said the first time?
It was about the same as the one played on the video.
Okay, so, I mean, there was an argument, right?
Yes.
And your subsequent investigation showed the text messages and some calls for, and I'm talking about April 3rd, 2022. We'll get to the other stuff later. Mm-hmm. But on April 3rd, 2022, you had the video of them in the morning. Doesn't seem like there's anything wrong.
Yeah.
Right? You have some text messages and some calls that occur right before that.
Yeah.
Right before around 4:30 p.m., correct?
Yeah.
Okay? And then we know things go bad, right?
Yeah.
Now, we know that because some neighbors called the police, right?
Yes.
They heard screaming and yelling.
Yes.
Right? We know that your investigation also revealed that Courtney was actually on the phone with her mom, right? Deborah
Yes.
Clenney. And she was actually on the phone with her at the time that Chris received the wound, correct?
When he received the wound?
Yeah.
Possibly, yes.
Okay. And so when Courtney's recounting what happened, she talks about a physical struggle with Marcelli, right?
Yes.
How big, meaning how tall is Mr. Marcelli?
He's taller than her.
Is he 6'2"?
Yeah. Low 6.
Low 6'1",
6'1", 6'2", something like that.
How much does he weigh?
I want to say about 200 pounds. Or,
Okay. And how tall is Courtney Clenney?
she's about 5'8".
And how much did she weigh at the time?
About 140, 150.
Okay, so it's Omocelli outweighs her by about 60, 70 pounds and is much taller, right?
Yes.
Now, she describes
Interesting that the lawyer is going here because there's no jury and this is a bond hearing. This is not a trial. And sometimes this happens in hearings like bail or bond hearings where they go over too much. And I think it doesn't serve the lawyer that well because, I mean, if she posed this much of a threat to a guy who was much bigger than her, well, you can't say, well, she's a little thing. She can't hurt anybody.
describes his attack on several occasions. I think the third time, right, she mentions that he got in a crouching position or he was crouching and then he came at her, right?
I don't remember that.
No, that's not her statement?
I don't remember that.
Okay. Do you remember her saying she could see the whites of his eyes?
No.
Did you review her statement before coming here to testify today?
Objection, counsel testifying. Also arguing.
I reviewed part of it.
Part of it, not the whole thing. So, again, but you're saying...
What's going on here? He doesn't remember. He knows he has to testify at a bond hearing, and he only reviewed part of her statement, not the whole thing. So was he not expecting that he would be asked questions related to these things? Or are they underfunded and overworked? What's up with that?
Her testimony from the first time you asked her to recount what occurred was similar to the third time, right?
Correct.
In the arrest, did you author this arrest warrant? And I'm holding it up. It's been admitted into evidence, and Judge, procedurally, I would move to submit, try to move into evidence all defense exhibits which were previously provided to the court. I believe
I have no objection.
defense exhibit A, I believe, was the arrest warrant.
I don't have any evidence from the defense.
Wait, I'm sorry, hold on. I misunderstood something. Can we approach that part?
Katrina's asking maybe he's not used to testifying. Maybe not. He's been in homicide for a year. Maybe you're right. But, I mean, they have supervisors. So it's just odd. It's just odd that he wouldn't have reviewed everything. Yeah, Courtney's saying maybe his caseload is huge. That's a possibility. Joan is saying, I see borderline personality disorder and intermittent rage disorder. And Joan worked in, I missed it, forensic a behavioral ward in forensics. Hope I got that right. Courtney's asking, sympathetic toward her in the first interview? Yeah. Yeah, he was. He might wonder why the heck he has to be there at all. Fast forward past the sidebar.
I think I was about to ask you about this, the affidavit in support of the arrest warrant.
Yes.
Did you author that?
I did not.
You didn't author
No.
the arrest warrant in this matter?
No.
Did you sign it?
I did.
Well, you're the affidavit, right? You're the one swearing to this document?
Yes.
Did you read it?
Yes.
Did you go through it?
Yes.
Line by line.
line by line.
Did you understand what was contained in this document?
Yes.
Let's go through the mischaracterizations of the evidence that are contained in this. I believe the first one.
I'm going to pause here because he is going to go on to something else, and I don't want to forget. I find it really weird that he, as the lead homicide detective, did not author the report, yet he's the one who swore to it. And I say I find it weird because here, that's not how it works. I don't know if it works like that in some places, but it does seem weird to me. I also notice his body language. He's not comfortable right now. So this is interesting. Now the lawyer is saying, well, let's talk about mischaracterizations. So I don't know if, we're going to find out, I guess, I hope, if he's calling them mischaracterizations because he himself is going to spin them later. I'm talking about the lawyer now. Or if they were mischaracterizations. We saw this in the, what was her name? The victim's name was Jennifer Dulos. Who was the woman on trial for that one? We saw in her trial a lot of mischaracterizations of evidence that were really mischaracterizations. So very interesting.
In this affidavit, you talk about, and this is going to be, and please let me know if you need to see this. This is a Defense Exhibit A. I think the government also introduced the arrest warrant. And this is on page 4 of 6. This is the second full paragraph. You stated, in her explanation to the police regarding the content of the phone calls that day, Clenney, which is Deborah, did not say she discussed the incident with the defendant. However, investigators know Clenney did communicate with the defendant about the incident because investigators saw a text message from mom on the defendant's phone reported at 5:25 p.m. that mentioned self-defense and advised her not to say anything to investigators without an attorney. In addition to omitting her conversations with defendant Clenney, in addition to omitting her conversations with defendant Clenney, recorded statement also admits any claim that the defendant said she was being attacked by the victim during the call. Do you stand by those words?
Can you read the last sentence one more time?
Yeah, I was showing an object in this characterization because he said admits versus omits versus what it says.
In addition to omitting her conversations with the defendant, Clenney's recorded statement also omits any claim that the defendant said she was being attacked by the victim during the call.
Correct.
Okay. You stand by those words?
Yes.
Okay. In your phone call to Deborah Clenney, did you ask her, hey, was Courtney attacked?
No.
Okay. So.
Oh my goodness. There is a big difference. Okay, this is the lawyer playing a game here. And he's going to do this at trial. There is a big difference between sitting back and letting someone tell their story and noticing that they omit really important things. It's much like what we do here, or what we've been doing, looking at all of this, right? There's a difference between that and having someone ask the person a question specific to that and the person leaves that out. It's not the same. He doesn't have to actually ask the leading question, by the way, in order to expect her to give that information. It's not like it's not like she omitted what she had for lunch or something. She omitted the key piece of information to which she's supposedly a witness. Who does that? I'll tell you who does that. Somebody who never saw or heard or was not a witness to the event. Somebody who's not telling the story. So that's what the detective did, or what the report is saying is valid and reasonable. And this guy is going to try and make something of it. So we know now that when he gets in front of a jury, he's going to use this. He's going to play this game.
When you say she omitted it, you never asked the question, did you?
Correct.
You also, in this paragraph that I read, you indicated that Dee Clenney, meaning Courtney's mom, did not communicate, or the investigator, I'm sorry, that Deborah Clenney did not say she discussed the incident with the defendant, meaning the attack, right?
Correct.
Okay. You didn't ask her about that, did you? Did you say, hey, did Courtney tell you about the attack?
No.
No, you didn't ask her that, right? So any omission is because she didn't volunteer it, correct?
Correct.
Now, while you're, I guess this paragraph says, while you're...
If you witnessed or overheard a horrific attack and the police called you and said, hey, we want to talk to you about this, would you omit that part? Would you omit the very thing that you witnessed? Really? Come on.
Interviewing her, I guess you saw a text message kind of pop up on Courtney's phone?
Yes.
And were you able to view that?
That's the answer. We already covered it.
A text message popped up on the phone, and I guess you're saying it mentioned self-defense?
Yes.
Did you see the entire text message?
I did not.
Give me one moment. So your inclusion of that portion that says something about self-defense, it kind of makes it sound like that's something nefarious or somebody's being coached, right? The way you wrote it?
Counsel testifying.
These are your words that you adopted, right? It kind of makes it sound like there's a cover-up, right?
Yes.
And you put these words in here without seeing the full and complete text message, correct?
Yes.
Now, on the screen here, I think it's Defense Exhibit C, right? This is the complete text message. At 4:04 p.m., which would be Texas time, so that would be 5:04 p.m., okay, Miami time. Please tell me what's happening. This is from Deborah to Courtney, my sunshine. Please tell me what's happening. You have to call me, exclamation point. Even though it was self-defense, don't say anything with the police without getting a lawyer first. Call me, please. It's very important. Even though it was self-defense, you cannot say anything without an attorney, exclamation point. Innocent people get in trouble all the time. Right? That's the complete message.
I want to say to the guy, like, I wish this detective could turn to the lawyer and say, yeah, so what? So what? She's asking what's happening, not what happened. What's happening? She wants to know, Mom wants to know, are police there? Are you at the police station? Is everything okay? Well, like, what's happening? Because they're all in there having, making sure that they can clean things up for Courtney. So that's not the same as saying what happened or I don't know. And it doesn't take anything away from the fact that Mom is saying, oh, blah, blah, self-defense. But it seems like Mom doesn't know what happened. Well, How could she not know what happened and then say it's self-defense? So what the lawyer's trying to do here is just falling flat. It's not logical. It's a real reach. People are talking in the chat about this detective's body language and his level of discomfort. I understand it. The lawyer's playing games with him, making it sound like he didn't do his job. We don't know why he didn't review every little thing. We don't know why he sounds unprepared. We don't know. We don't know how much time he had to prepare when the prosecution said he was going to have to be called to the stand. So, yeah, he probably is uncomfortable.
And this is a mother, right? That's in another state, right?
Objection, counsel testifying, no questioning pending, both to everything that we just said and now.
Sure. Do you know where Miss Clenney was, meaning Deborah Clenney, on the date of April 3rd, 2022?
Yes.
And where was she?
Texas.
And where was Courtney?
In Miami.
Okay. So, what seems clear to me, and correct me if I'm wrong, but it appears that Miss Deborah Clenney was unable to contact her daughter at least between 5:04 p.m. Miami time, and then even going into the late night of 10:46 p.m. There's no responses, right, by Courtney?
Correct.
So this could be a very concerned mother, correct?
Yes.
Okay. And Deborah was on the phone with Courtney listening to the argument that night, right?
Yes.
So this happened just before 5 o'clock. And at 5:04, when mom cannot reach her daughter, and if, as the claim is, she heard this whole thing go down, why then? Why is mom not calling 911?
And I believe she told you that when you interviewed Miss Clenney, Deborah Clenney, that she could hear Christian yelling.
I believe so.
Again, you weren't in the apartment that night, were you?
No.
Now, you testified previously that her first and third recitation of her statement of what happened that night about the attack was consistent, correct?
Yes.
This is page 4 of 6 of the arrest warrant whose language you adopted. Actually, you know what? Let me stop you there.
I think some of what we're seeing here with the detective, I think he's got back pain or neck pain. Yeah, we're seeing mouth grooming. We're seeing some, soothing with the hands and all of that. But I think some of it is actually he's got a sore back or a sore neck or something. I don't think that is all discomfort.
If you didn't write this, who wrote this?
State attorney.
Which state attorney?
Khalil.
Mr. Quinnen?
Yes.
Now, in this paragraph, which is the third full paragraph, again, page 4 of 6, you say,
Well, that's weird. So it's not like the detective. So we know the detective didn't author the report. And it's not even like he delegated the task to somebody else on the team and then signed off on it. It was the state attorney who did that. So this is really weird to me, but it could be just because things are done differently here. Has anyone ever heard of that before? Is that a thing that happens in the United States? Does it seem odd to you? And I'm just watching the chat to see if anybody has any response to that. Okay, I'm I'm going to keep going, and I'll keep an eye out for your comments.
Although the defendant admitted to having caused the victim's injury in her post-Miranda recorded statement, she also provided several inconsistent accounts about the incident. Now, you just testified that at least the two of the three are consistent, right?
Mostly.
So this could be perceived to be a little bit misleading then, correct?
No.
There's a rule, and I don't know about the states, but the principle will be the same. Prior consistent statement is not something that should be construed as evidence of the truth. And the reason there is a rule like that is because people rehearse statements, and prior consistent statement could simply be that, people rehearsing a lie. Prior inconsistent statement is important because it's worth looking at. The question becomes, why is it inconsistent? So a lot of people believe that if somebody's telling the same story over and over and over, it must be the truth, but that is not necessarily true. So this lawyer is trying to grab at that straw of, but she said, but there was a prior consistent statement. So the lawyer is doing the same thing he's basically accusing the detective of doing, which is ignoring part of this and latching on to another part. Well, the lawyer wants to disregard Courtney's inconsistencies and only focus on the consistencies, which is hilarious. But you want to bet he's going to do this in front of a jury because the judge knows better. There's no jury here. He's just playing with this guy.
You had crime scene, or somebody had crime scene respond to the homicide bureau, correct?
Yes.
And I think I may have been there when they came to photograph her.
I can't remember.
I can't remember either.
Yeah,
It's neither here.
but-
Okay, sorry, I'll move on. So they came. One moment. Sorry, I forgot where it was. So crime scene did come out to the homicide bureau and they photographed Miss Clenney's physical condition, correct?
Yes.
And that is done to document any injuries, right?
Yes.
You don't take the photographs yourself, do you?
No.
These crime scene technicians are specially trained, correct?
Yes.
And they have like rulers that they can take out to measure things when they're taking photographs, correct?
Yes.
Okay. And in your warrant, well, in the warrant that you signed, again, the last full paragraph, the defendant's physical body was documented on the date of the incident, and there were no injuries to her person to corroborate this account. Now, do you recall that being included in the warrant?
Yes.
Okay, and that's for the record and for your honor.
So the lawyer is going to say this is a mischaracterization because there were bruises. He's going to do this in front of the jury. He's going to say, oh my gosh, see, there were bruises, and want to get people ramped up. They're lying. Except what was written in the report and what this detective is saying is not a lie. It's not a cover-up. He didn't say there were no injuries, period. He said there were no injuries to corroborate her story of what happened. And that is true. Lawyers playing games, going to accuse the police and the state of mischaracterization, but they're not.
Page 406. Now, on the screen, which is Defense Exhibit H, these are crime scene photos, are they not?
Yes.
And these are taken by your department, correct?
Yes.
And these was then provided to the state and then provided to the defense, right?
Yes.
Okay, on the left side of the screen, there seems to be a bruise on the inside of her right arm. Do you see that?
Yes.
Could that bruise be consistent with a physical altercation?
At some point,
Objection,
yeah.
proper opinion. He's not an expert.
Do you see a bruise, a visible bruise on Courtney's sorry, that's the right arm? Do you see that?
Yes.
And on the right side of the screen, it looks like it could be an abrasion. I don't know, there's a mark there that we circled on the right shoulder. Do you see that mark?
Yes.
Could that mark be consistent with some kind of physical altercation?
Yes.
Yes, that mark could be from, and we saw this a couple of times in videos, from her going after him and him grabbing her to try and stop her, from him trying to hold her hands down. And by the way, a bruise like that, I mean, you don't have to be an expert to know this. A bruise like that isn't showing up on the same day, isn't showing up right away at the time of the offense. So the detective is still right. This is nonsense. But this is all practice. This is all practice. This lawyer is going to get whatever clues he can get from not just the state, but also the witnesses, to look for chinks in the armor, to look for ways that he can push buttons, manipulate, that kind of thing.
We also have crime scene photos. Again, the inside of the right arm. This is I think the closer up view of what we saw a second ago. And in this picture, there's a ruler, right?
Okay, yes, sir.
And if you need to get up with your Honor's permission, if the witness needs to get down, thank you, Judge. And they measure that just so there's some type of kind of comparison, or if they need to describe the extent of an injury, right?
Yes.
And they take that out for something that they think is important to document, correct?
Yes.
So then we go on the again, another crime scene photo, lower right leg that we've taken the liberty of circling. There seems to be some discoloration there, correct?
Yes.
And that could be bruising, maybe not. You're not an expert, right?
Correct.
So these pictures actually do show signs of physical injury, right?
Yes.
Judge, can we approach that bar?
That basically throwing a knife from that distance in that manner couldn't have caused that wound. Is that basically a summary of what he told you?
Yes.
Okay. Are you a knife expert?
No.
Is the medical examiner a knife expert?
I don't know.
Oh, I have a question. Mr. Lawyer. Is Courtney Clenney a knife expert? Is she such an expert at knife throwing that she could have done that as she described and caused that injury? Oh, right. Yeah, we're not supposed to ask that question.
Now, in the when the state was up here asking you a question that this has to be a stabbing, he motioned in a very almost a 90 degree motion, downward stabbing. Do you remember that?
Yes.
Now, is what the government the state attorney, was that gesture, is that accurate and consistent with what the medical examiner's report says?
Yeah.
Really?
Yeah.
I don't recall the warrant that we read stating 90 degrees specifically, just that it set a downward angle. I do recall Courtney demonstrating like she had like this, right? So I could be missing something. It could have said 90 degrees, but I don't remember it saying that. That's the lawyer saying this.
Detective, did you review the report from the medical examiner?
Okay. So, objection and proper impeachment. Also, it's going to be mischaracterization.
Yes.
And Detective, you did review the medical examiner's report, correct?
Yes.
And his report indicates that it is a slight downward angle, correct?
Yes.
Testified on direct that you didn't see any bruising or marks around Courtney, is that correct?
Correct.
In her statement to you, she did mention that he grabbed her by the neck or had her up against the wall by the neck.
Yes.
And have you ever seen a particular situation where somebody could have their forearm up to somebody's neck,
Yes.
and that wouldn't necessarily cause bruising, would it?
Objection, Judge, that's a speculation.
And that's not what Courtney said anyway. She didn't say he had her in a headlock. She didn't say that. She said he grabbed. And not only were there no marks on her neck from him doing that, there were no scratches from her trying to, get him off. And it would be interesting to know, I think if it was present, the defense would bring it up, whether or not there were scratches on his hands or forearms from her trying to fight back or get him off of her. We haven't heard anything like that. So he's just going to play let's make believe, and we're just going to throw a whole bunch of little pieces here together to hopefully make them fit. All you need is one juror who is willing to play let's pretend. Well, we got to go with the evidence. Katrina is saying she probably told something different to the lawyer. Perhaps.
And Ms. Clenney indicated also that at some point he threw her down to the ground, correct?
Yes.
Before? And I think she said on her shoulder.
She wasn't able to explain to me how he put her on the ground.
Right, I think she said something, and then I was on the ground, right?
Yes.
Okay, which somebody who's just experienced a traumatic experience that Courtney experienced, that wouldn't necessarily mean that she has an accurate memory, correct?
Objection, speculation,
Detective, have you ever been in a fight before?
objection.
You answer? Okay. Yes.
And was it a traumatic experience?
I mean,
Do you remember every detail about that fight?
well, I grew up doing martial arts, so yes.
In Courtney's statement at one point, she said she was able to break free, correct?
Yes.
Or she was able to get up, right?
She wasn't able. She was able to. She explained that he wasn't on top of her anymore, but she was able to get out. But she couldn't explain exactly how.
And you testified again after looking at the crime scene, after speaking to Miss Clenney that night, after you spoke with me, you were looking at this case as a case of self-defense, correct?
Yes.
Now, as part of your investigation, did you try to canvass the area to find other witnesses?
We attempted to contact other members of the building, in the same hallway as well.
And were you able to locate the witness that said he saw Christian hitting Courtney in the head prior to April 3rd, 2022?
I could not find him.
But you heard about that witness, correct?
Yes.
It was reported to you by somebody else, right?
Yes.
And I believe that account was told to you that that person wasn't sure if it was a closed fist or an open hand, correct?
Yes.
But so you do have some evidence, right, throughout the course of your investigation that at a minimum, Maselli also hit Courtney at least once that you're aware of.
From what I was told, yeah.
Did you also interview any witnesses, neighbors in this case?
I attempted, but they refused to talk or be involved.
When you say they refused to be involved, what do you mean?
Like they didn't want to they didn't want to talk to me or give any type of statement.
And that was all the neighbors in the building?
Not in the building, but actually, hold on. I did speak to two gentlemen.
Okay, you did speak to two witnesses, right?
Yes.
One whose initials are JS and another one's initials who are EB, correct?
I can't remember right now.
Detective, so I don't want to necessarily put their names on the record now, but one of the witnesses, JS, I guess. So the first person you interviewed, remember the first gentleman you interviewed?
Someone in the chat is saying maybe a bond hearing is like a mini trial without a jury, but I do not see how these questions help the judge decide bond. So sometimes what happens is the defense will say, there is not enough evidence to even proceed to a trial. There's not enough evidence, Judge. The strength of the prosecution's case is so weak that it would be an injustice to have my client sit in jail waiting for a trial on this matter. that by itself isn't going to get somebody out on a bond, but that is sometimes something that they bring up. And this detective's, I don't know, almost like it's so slow in answering the questions. The lawyers asked him, do you remember the first person, this first witness? And he seems to not know, but then he seems to just not even be trying to remember. Now he's just watching the lawyer. He's not even trying to remember who that was. So very interesting.
I don't want to play your whole interview. I have some excerpts that I'll play later for the court so we can move through this. But in substance, would you agree that that individual basically said he had seen incidents of, I think, Christian Moselli chasing or running around Courtney's car trying to gain entry? Do you remember that?
Yes.
Okay. And that same individual also, in that same interview, said basically, look, I know a victim of domestic violence when I see one, and Courtney was a victim of domestic violence, right?
Objection and proper.
Correct. I mean,
So the lawyer's going with this. So on the one hand, the lawyer is saying, you didn't read the entire text message. You are taking things out of context. You need to see the whole thing. But when a witness says something he likes and that witness doesn't have the entire context, well, that's okay then. That's okay then. Sometimes witnesses see something, they don't even know that they're a witness. They have no idea that that thing they saw is important. So they don't come forward. And sometimes people see things that look really scary. One time I saw somebody throw another guy into a vehicle and take off, and I chased him. I thought I was witnessing like a kidnapping, but it wasn't. It was they had just committed a robbery, and the one guy was throwing his buddy in the car to escape. So just because you see something, it doesn't mean you know really what happened. You extrapolate and you look through your lens. Courtney saying, and this guy saw a snapshot in a much bigger story. Yeah. And hey, if there is evidence out there that Christian did something, then there is. And it'll come in, and that would be proper, right? But you can't construct the rest of the story around a little thing and say that's the thing, that's it.
If that person's opinion is improper, and the way the person is improper as well.
that interview, in your interview of that individual, he opined, and it was his opinion, right, that Courtney was a victim of domestic violence. Is that true?
Yes.
Now, you interviewed another gentleman. I think it was just right after that.
Yeah.
And that individual recounted the scene at the dog park, correct?
Yes.
And in that recounting of that scene, right, he talked about Christian grabbing her aggressively in the tricep area, correct? And he also told you that he stayed around and stayed in case something, quote unquote, went down, correct?
Yes.
Because he was concerned.
Yes.
And I think he also mentioned that Christian had his hands up her face, correct?
I don't remember.
Now, I want to go back to the phone interview that you had with Miss Clenney, Deborah Clenney. You remember that?
Yes.
And actually, you never asked the questions about did you describe the attack and the stuff before. You remember that?
Yes.
And part of that is because I showed up at the homicide bureau, and that kind of ended the phone call, right?
Yeah.
right? I mean, you were kind enough, very cordial with me, very professional with me, and you allowed me to come in, right?
Yes.
And that terminated your call with Miss Clenney, right?
Yeah. I mean, we were pretty much almost done with the call.
Okay. And in that, well, you never called Miss Clenney to follow up and do another interview to get more details?
No.
You never called her husband Kim to maybe follow up because you said he was on the line. You never followed up with him, right?
No.
You didn't call me and say, hey, can you talk to Deborah Clenney and have her make a statement to me?
No.
You know, by the time that later rolls around, talking to Deborah Clenney again isn't going to produce much that is actually reliable. And the reason why is because you've got the witness, a main witness, and the defendant in the same family, and they're in communication all the time. And the witness has historically been a fixer. So why would the detective, I mean, I can think of reasons why he would, but you can understand why he might not go and re-interview her, because it's not going to produce anything that is reliable. But I can see where this lawyer is going. He's going to get up in trial and make the jury believe that this was a shoddy investigation and it's incomplete and they didn't do all, didn't investigate everything. But, don't look at the evidence we do have. Just look over here.
But what she did tell you was she overheard Courtney saying, stay back, right? Stay back.
Yes.
And then we know, based upon your cell phone analysis, right, that Courtney called 911 herself, right?
Yes.
And we heard it. She's there panicking, trying to get help, right?
Yes.
And again, when the first responder showed up, she was cradling Mr. Umbrumselli in her arms, correct?
Yes.
Now, you also served...
This is like the third time this lawyer has pointed this out. She was cradling him. So you know that when it comes to trial, he's going to focus on how much she loved him and how she tried to get him help. This was not a diabolical, intentional thing. She tried to get him help. And honestly, that was one of my first thoughts. Well, okay, she called 911. Until you start looking at the times from when he got back, there was only like 10 minutes between the time he got back and all HE double hockey sticks breaking out and the times that she's on the phone with mom, and the fact that it was residents and security who called 911 before Courtney did. And you'd have to overlook the blood evidence, the pooling, and the moving around. And the fact that she's cradling him. I'm not hearing how she's trying to actually render aid, applying pressure. None of that. So the story is going to be a love story. This is not love. Not at all. Katrina says a lot of perpetrators, I'm going to say, I keep getting demonetized, say they love their victim. Yes, they do. Yes, they do.
Well, let me ask you this. Did Courtney, during your interview, she was remorseful, right?
Yes.
Objection, relevance.
right? She seemed remorseful and genuine with you, correct?
Yes.
Objection calls for ability of the witness to use this right.
You said you executed some warrants in this case, one of which was
Before they move on, I want to address the remorseful thing. There is remorse that sometimes they do show. Sometimes there's remorse that is, oh my gosh, that, I didn't intend for it to be this bad. Courtney, in her own statement, said, I didn't want to do that to him. If he was injured, that would be okay. So, and sometimes remorse is real to a level. Sometimes the well isn't that deep. You know what I mean? It's transient. It's not enough remorse for her to change her behavior, for her to seek counseling, to seek help for her behavior. Not enough remorse for that. It's transient.
financial documents, right?
Yes.
And those financial documents were of Courtney?
It was a subpoena, and yes, it was of Courtney.
Okay, and you got a response, right?
Yes.
And, did you serve a subpoena on Muselli's bank accounts?
No,
Why not?
no reason.
Do you know how he was supporting himself?
I don't recall.
Objection relevance.
I understand he's saying there's no reason to get the victim's bank records. I would think, just in the interest of completeness, that you would want to look at that. So this seems odd to me. And this lawyer is going, I can't believe he's going here. How did he support himself? Well, he wants to go into how it was Courtney who supported him. It doesn't matter. It doesn't change that her behavior wasn't okay. It doesn't matter in that respect.
Did your investigation reveal that he was a cryptocurrency trader?
Yes.
Judge, you can hold on of inquiry here.
Line of questioning. You did serve a subpoena though on the building, One Paraiso, correct?
Yes.
And as part of the documents you returned, you obtained a lease agreement, correct?
Yes.
And whose name is on that lease agreement for the apartment where this incident took place?
The defendant.
Just like she said, it's my name on the lease. I paid the lease. This is a Sarah Boone. This is a Sarah Boone getting her lawyer to say something. It doesn't matter.
Courtney's name.
Yes.
Is Muselli's name anywhere on that lease agreement?
No.
As part of you serving subpoenas on the bank accounts and financial records of Courtney, did you see the payments being made for rent?
I can't remember.
Do you have any evidence that Mr. Muselli ever paid rent?
Again, Judge, relevance is...
I can explain the relevance, Judge.
This is irritating me because it doesn't change the facts. It doesn't change what she did. He had a right to be there. He was an authorized guest. And this is like, it's hints of he's somehow less valuable or less valid because he didn't pay? Right? Did he owe her something? Did it entitle her to treat him badly because he didn't pay financially? Really? Really? No one in this freaking century thinks that, do they? Come on, weren't we over that years ago? I bought you dinner. You owe me. I pay the bills. Therefore, I can do whatever I want, no matter how it affects you. Come on.
Did you find any evidence that Mr. Moselli ever paid rent?
No.
Now, part of your investigation also revealed that the week prior to April 3rd, 2022, Miss Clenney had to fly in from Texas to help Courtney get him out of the apartment, correct?
Yes.
And at some
For the lawyer who claims that the state and the detective are mischaracterizing things, well, he just did something right here. He just slid something right in here. That Courtney's mother had to fly in from Texas. Like, she had no choice. She had to do it. That's not what Courtney said. That's not even what she says. It sounds like Mom wants Courtney to get rid of Christian, to break up with him. And Courtney said she didn't really want to. But he's going to do this in front of the jury. Oh, the mother had to come out.
point, he was thrown out of the apartment, correct?
Yes.
And then he came back, right?
Yes.
So during the time that he was out of the apartment when Miss Clenney was there, do you know where he stayed?
No.
Did you interview any of the employees of the building that said he was living in a common area inside the building?
Objection, counsel, testify. There's two questions within that one question. One of which is testify.
Did your investigation reveal at any point that Mr. Moselli was staying in common areas within the One Paraiso building?
Yes.
He's going to make this sound like Christian was a stalker. And I can see how he's going to be able to pull this off, right? Because he stayed, even though he's kicked out, he stayed. He slept in here. Oh, it looks really creepy. And anyone who's experienced that sort of thing is going to get, right? If you take it out of context of everything else. I mean, the fact is he had nowhere else to stay. And whether or not you agree with his decision, it is what it is. She didn't actually want him to leave. And Courtney in the chat is asking, what special abilities does mom or dad have to remove him from her life? Sometimes, yes, sometimes that happens. I think this is a different conversation.
Now, you discussed the manner in which you get up to the apartment in the elevator. Is it fair to say that you have to have a key fob in order to get into a specific apartment?
Yes.
And that particular fob is programmed only for that particular floor or apartment, correct?
Yes.
And the elevator, when it opens up directly into the apartment, correct?
Yes.
So once somebody gains access to the elevator, activates the fob, the next stop is the apartment,
Yes.
right? Now you testified about an elevator video, the infamous elevator video.
Same objection as judge.
You previously testified about the elevator. I understand. You previously testified about the elevator incident where you say Miss Clenney was attacking Christian.
Yes.
Okay. You just have the video, right?
Yes.
What happened before they got in the elevator?
We don't know, or I don't really recall what happened before.
Oh, you know where he's going here. He's going with, well, you're taking it out of context because there's a rational explanation. Because for her doing what she did, and you just didn't see what happened before, which is rich, considering he wants other stuff that benefits him to be brought in, even though that was taken out of context. But let's just play a game here. Imagine for a second, you saw that elevator video. Imagine for a second he had been horrible to her. He'd done something. He scared her. You know, imagine the wildest thing that you can. Whatever had happened was over. She held the door open and she launched into an unprovoked attack. And maybe I'll restate it, an attack that was clearly not self-defense. So maybe she was mad, maybe all kinds of other things. She held the door open and she didn't run out of the elevator. So it doesn't matter what crazy thing you can come up with that happened before.
You don't know what happened before that elevator video, correct?
Yes.
Did you interview any witnesses that told you what happened before that incident in the elevator?
No.
So all you have is a video.
Yes.
No context to what occurred prior to Courtney getting on that elevator, correct?
Correct.
Now, she seemed pretty upset in that video, correct?
Yes.
And at some point, Mr. El-Moselli is able to gain access to the control panel to get the fob, correct?
To use the fob, yeah.
Right. And that fob
To get the fob, was he hoping that this detective would miss that and not say to use the fob? Because it was Christian who had the fob. And it wasn't that he gained access. She wasn't going anywhere unless he used the fob. So if she wanted to go upstairs, she's not going anywhere unless he used it. Jenny says he was way too calm as soon as he got in the elevator that it would be hard to imagine that he just did something, right? There was a big thing. Yeah. She also held the door. Yes. Otherwise, she could have gotten away. Yes. She waited. Yes. And she didn't run out. She's not screaming. She's not pushing him away. She's striking him. Very different.
would take him directly into the apartment, correct?
Yes.
So the only way to get Mr. Moselli not to go to that apartment would be to not allow him to use the fob, correct?
Yes.
Do you know if Courtney wanted him in the apartment that evening?
Judge, that's speculation.
Again, that was a month and a half prior to April 3rd, 2022?
Yes.
As part of your investigation, did you review body-worn camera footage of an incident that took place at the One Paraiso condominium April 1st, 2022?
I did, but I don't remember what was on it.
Would that video, if you can recall, would that video have depicted some officers responding to a domestic dispute?
Yes.
And in that video, do you recall Courtney explicitly saying, "I want a restraining order against Christian Moselli"?
Yes.
Interesting, though, and this is going to get left out, and I hope the prosecution brings this up at trial, that she requested this restraining order after she thinks that she might get evicted. Her concern was, I don't want to get evicted. And she also said, I need to get there first because he's going to do it. And since we viewed that, we have learned that he was planning on leaving. And she doesn't want him to go get a restraining order first. She wants control. So, very interesting that this defense lawyer is going here, because he's going to play this at trial.
You didn't put that into any of your reports, did you?
Not yet.
Now, Detective, in April of 2022, you had been with the homicide unit for less than 1 year, correct?
Yes.
Prior to that, what was your assignment?
I was in robbery.
And prior to being a robbery, sorry, I cut you off. I didn't hear your response. You were a robbery detective and you were going to say something else.
No, that was just it.
Prior to being assigned to the robbery unit, where were you?
I was in the problem-solving team. I was in the problem-solving team in Overtown.
What? I'm not familiar. What is the problem?
That's just a unit that proactively works on ongoing issues within the community.
Okay. And prior to that, I'm going to guess you were on patrol street?
Yes.
Okay. In a marked unit?
Yes.
Okay. During the course of your experience while being a police officer, did you run into victims of domestic violence?
Yes.
Objection, relevance.
Are you familiar? Let me ask you this: when you're in the police academy, or as part of your ongoing training as a police officer, are you trained to notice signs of domestic violence?
Same objection. Also, a proper opinion. I can keep going.
I'm asking if he's been trained or not. I understand. Have you been trained on detecting signs of domestic violence?
Yes.
Are you trained about what they call the cycle of violence?
Objection 702.
As part of your investigation, you indicated that you also subpoenaed or obtained police reports from Las Vegas, Nevada, correct?
Yes.
And you talked about that at length with the state attorney on direct examination, correct?
Yes.
And in your subpoenaing of those records, in addition to the police report, also came a statement, a sworn statement, by one of the hotel security officers. Does that ring a bell?
Yes.
And in that report, well, let me ask you this. Did you review the body-worn camera of that incident?
Yes.
And I believe the investigating officer was Detective, or I think Officer Velasco?
He was an officer. I don't remember the name though.
Okay. And this is the video, just so we can make sure we're talking about the same one. The video of the officer who first goes to see, I think speaks to Mr. Amroselli,
Yes.
and then talks to Courtney.
Yes.
But the first person he talks to is, I think, some member of the hotel security staff, correct?
Yes.
And when he approaches that individual gives him kind of a summary of what they have, so to speak, correct?
Yes.
And what he says is security got called, right?
Yes.
Who called security?
I can't remember.
Well, was it Courtney or was it Christian?
Honestly, I can't remember.
Okay. If I told you it was Courtney, would you believe me?
Same objection as you.
So you don't recall?
I don't.
Well, we'll play it for you, or not for you, but we'll play it later.
Okay.
So do you recall that person telling you that his security people came into the hotel room and noticed clumps of Courtney's hair on the floor?
Yes.
Now, as a trained investigator, clumps of hair on the floor, would that indicate some kind of physical struggle to you?
Objection. speculation, Judge.
You can answer the question.
Yes.
Now, in that interview, Courtney admits she threw a glass at Christian, right?
Yes.
The glass didn't hit him, did it?
I'm not sure.
Also in that video, Courtney tells the officer right before she's being arrested that she didn't tell him the whole story, right?
Yes.
Because she didn't want Christian to get in trouble, right?
Yes.
What did she want then? If she calls security and she doesn't tell the whole story and admits, I didn't tell you the whole story because I don't want him to get in trouble, what did she want then? So there's an outstanding question there. And the other thing, considering context is really important here, is what was the context of her saying, I didn't tell you the whole story? Why does she admit that in that conversation with I guess, police or security? Why is she admitting that? Was there something that she wanted from authorities that she wasn't getting, so then added that? I don't know. But you know this lawyer is going to try and make it sound like this is part of the cycle. Well, you know what is part of the cycle? When Christian doesn't call security.
So you testified as to the medical examiner. I think you indicated that in your interactions with him and reading his report, the manner of death was homicide, correct?
Yes.
By a single stab wound, right, to the subclavian artery, correct?
Yes.
Now, in your training experience, even a homicide, right, can be justified, right?
Yes.
And initially, you didn't make any arrests because you were looking at this as self-defense, correct?
Objection.
Yes.
Now, you talked about blood spatter and
Droplets?
droplets and pooling of blood, right? But you're not a blood spatter expert, correct?
No.
You were just recanting what's on the scene that you saw, right?
Yes.
And that the blood, as far as you're concerned, was consistent with somebody sustaining an injury and then walking around the apartment or running around the apartment, right? You don't have to look at the state. You can look at me when you answer the questions.
Okay.
Just relax. Okay. Just make sure that you are, he's asking the questions, the state will object, if they have an objection, I will move the orders. If I will move the order, then you can answer the state and you don't answer yes.
Objection.
Grounds.
Several. Several two states direct. I mean,
Right now, we hear the question.
So is the blood that you saw at the scene, I'm not asking you for an expert opinion, but it's consistent with somebody walking or running around the apartment after sustaining an injury, correct?
Yes.
Now, do you know, again, you weren't there when the injury occurred, right?
Correct.
Interesting that the defense lawyer is reiterating that the physical evidence at the scene is consistent with him walking around, and I kind of laugh because he also threw in there or running around because that makes room for yet another story if it's needed. When that scenario is contrary to what Courtney told police, which was that he fell right away.
You also mentioned in the Las Vegas video body cam, I think that Courtney said, oh yeah, I threw a plate at him or something, some other stuff. Is that correct?
Yes.
Okay. Are you Hispanic?
Yes.
Okay, do you have an abuela?
Jack shit.
Wow. Wow. Oh, I don't like this guy. I don't like this lawyer. What a piece of work. Wow.
Do you have a grandmother? I'll move on. Do you know what a chancleta is, detective?
Jack, judge, objection.
I'll move on, Judge. I'm sorry. Now you also said you pulled Miss Clenney's entire criminal history, correct?
Yes.
And you said it was a California case? That was
Yes.
a DWI or DUI?
I think they call it DWI over there.
Right. And that was a case that the charges were dropped, right?
I don't. Right now, I can't remember.
And the incident in Las Vegas, where she was arrested for battery, right? That case was also dropped, correct?
Yes.
The fact that a case was dropped could mean many things. Cases are dropped for many reasons.
You also testified that you did a cell phone extraction of Mr. Umbaselli's phone, correct?
Yes.
And you were capable to do that because Ms. Clenney gave you the passcode for that phone, right?
Yes.
She was cooperative with you during your investigation, correct?
Yes.
And in fact, I offered to be cooperative with you throughout the course of your investigation, correct?
Yes.
I'd call you every now and then just to follow up, right?
Yes.
Or I would text you, right?
Yes.
And I even said, hey, look, if something changes in your investigation, let me know and we'll go to your office. Surrender her, right?
Yes.
Detective, in extracting that cell phone, you testified on direct about text messages, specifically text messages that took place on October 9th and 10th, I believe it was. Do you recall those text messages?
Yes.
And I believe those, basically in summary, you said that those text messages indicate that there was a physical altercation and Courtney hit him in the head with a phone, correct?
Yes.
There was a physical struggle, correct?
Yes.
Do you know what happened that caused Miss Clenney to take that drastic action?
May I review my notes real quick?
Sure.
No, I don't remember right now.
Okay. And I think it was, again, this is State's Exhibit 4, is the text messages from October 9th, where he mentions that I think Christian says, oh, and stabbed me in my leg or something to that effect,
Yes.
right? In the follow-up text messages by Courtney responding to that, she never admits to stabbing him in the leg, correct?
I would have to go back to the messages for that section.
You don't remember?
She doesn't admit to it. Well, you got to remember, these are text messages between the two of them. So if somebody sent you, if your friend or your partner sent you a text message saying, yeah, I was really mad at you when you did XYZ to me, if you never did that thing, you'd be saying, what? What are you talking about? I did no such thing. So no, she didn't admit, yes, I did XYZ to you, because it's not necessary, because they both know it. So she doesn't admit it. That doesn't mean she didn't do it. And if she didn't deny it or say, what the heck are you talking about? Well, that absence of such a statement is also evidence.
No, not right now.
I mean, that would be something important, right? That you
Yes.
would have noted
Yes.
if she would make an admission of stabbing him previously, correct?
Yes.
Okay. Did you know that Christian would harm himself sometimes by cutting himself?
No.
You didn't know that? In your
We don't know if that's true about Christian or not. We do know that I think near the very beginning of Courtney's police interview, she does say that he would do that, and the story sounded weird, right? And she said, and so she ran to the bedroom because he'd gone to the bedroom and shut the door. And she ran to the bedroom because she thought, oh, gee, I should rescue him. So it was clearly a narrative. And for her now, and for the lawyer now, to use this allegation that is unsubstantiated, right? To use that is, I mean, them setting up to explain away his prior injuries. It's not that different from saying, oh, she walks into walls all the time, or he bumps his head on the doorknob all the time.
interview of Courtney, did she not disclose that to you?
Objection. It's still not relevant. And the court has to report.
Can you say it again?
Did Miss Clenney, during the course of your interview with her, tell you that Christian would cut himself?
I remember that she said that he tried to hurt himself at one point, but I don't remember to what extent.
Okay. Now, the text messages on State's Exhibit 4, which I have up on the screen. Do you remember this text message, which came hours later, after Christian describes being hit with a phone? Do you remember Courtney's response? It looks like 4:34 a.m., whatever time that was. I think this is in Las Vegas. Do you remember, if you decide to get, this is Courtney, if you decide to get security, call, I will let them know exactly what happened.
What's the question?
Do you
Oh, that's interesting. So the allegation is that she was hit on the head with a phone, and the discussion is then Courtney saying to Christian, if you decide to call security, well, that is out of character. That's off script from what came before. It's her who calls. It's her who complains. It's her who has control. And here we're hearing that he is considering getting help. Very interesting. So there was a change in dynamic there.
Oh, if I remember that? Yeah.
So is it fair to say that these texts don't say exactly what happened?
No.
And it appears to me Courtney's not afraid of telling somebody exactly what happened, right? That's her text?
Correct.
Now, you also have text messages from January 30th which you went through with the state, that talk about where he actually goes to the hospital and receives stitches, right?
Yes.
And he's cut across, his chin and I think you said his cheek, correct?
Yes.
Now, I think that was an argument over some text messages, right?
Yes.
Again, we don't know what happened in phone calls, perhaps, prior to the text messages.
No.
We don't know what conversations they may have had, correct?
No.
All we have is these texts, right?
Yes.
Again, this is where the state indicated that she said, oh, I hope you enjoy the hospital, something to that effect. I just hope you have time to cool down or think about your actions, right?
Oh, I don't know about cool down, but
Well, hopefully, again, Courtney's text, hopefully this will give you time to think about your actions, right?
Once again, this lawyer who is accusing the state of mischaracterizing, he mischaracterizes. Because Courtney didn't say, cool down, calm down. It's not Christian who's, blown up. It's her. She was mocking him. Yeah, I hope you enjoy the hospital. So he is characterizing this, and the witness can't argue. The witness can only say what he saw, whether or not it said a specific thing. He is going to play this game in front of the jury. This is what he's going to do. That's what you're going to see. So, oh boy, this is going to be another irritating one because he is going to mischaracterize. He knows that you want to plant seeds, that you want to spin, that you want to evoke emotion. What got glossed over in this whole exchange was that Courtney saying, well, I'll tell them then, and take everything he's saying and suggesting, implying. He wants the listener to come up with something in their own mind. And what is a listener most likely to come up with? A stereotype. That's what's most likely going to come to your mind, even if you are trained, even if you know better. So in order to avoid just going with that stereotype, you have to be thinking about your thinking, if you know what I mean. We don't know. You take what his own arguments and reverse them. Did she tell him or suggest to him at any time that, well, if you complain, I'll tell them how horrible you are? Because that happens. And you see this in DV. If you tell, no one will believe you. They'll believe me. If you tell, I'll tell everybody how crazy you are. And they set it up. They let people know ahead of time, oh yeah, this person is a little off her rocker. So that when the allegation is finally out in the open, they can say, well, I told you she was this way or that way, or he was this way or that way. So we don't know that isn't what she was doing. I'm not saying she did. But we can take this lawyer's arguments and switch it around.
yes.
Oh, yeah. Katrina says, tell the world, Johnny. Yeah. This one reminds me so much of Amber Heard.
I'm sorry, cool down, those were my words. All right? Enjoy the hospital. Right? You don't know what prompted her prior to these texts to send these, do you?
I mean, enjoy the hospital. Nobody wants to enjoy the hospital.
Right, but you don't know what occurred, right?
No.
Okay. Now, again, in the follow-up message, right, Courtney tells Christian, tell them your side, then I'll tell, sorry, I'm getting older. Tell them your side, then I'll tell them what happened. Right? She texted that.
Yes.
Is somebody who's afraid of the truth coming out, would they send a text like that?
Objection, speculation.
I'll move on. And his
So he's saying, oh, is somebody who's afraid of the truth going to send a text like that? Yeah, maybe. Maybe if she's got a lie planned. And let me ask a slightly different question. Is somebody who's afraid of the person they're talking to going to send a text like that? If he is all this thing she says he is she going to be acting like that to him? I don't think so.
his answer is that I'm not saying anything,
Yes.
right? I mean, people could not want to say anything for a bunch of reasons,
Objection,
right?
counsel testify.
One of which could be that Christian doesn't want the truth to come out, correct?
Objection, speculation, counsel testifying.
Then I think her next test is an LMAO, right? And then followed by you should, meaning she's asking him to tell whoever what happened, right?
Objection, speculation, best evidence, counsel testifying.
Can you repeat it?
I'm saying after the LMAO, her text says you should, meaning you should tell somebody what happened, right?
Yes.
I mean, that's the logical reading of this, right? I'm not making this up.
Objection, counsel testifying. I just want to ask the court director, counsel to stick to the premise.
Did you, I think you indicated that the photograph of his stitches pinged that the GPS data associated with that picture put him at Mount Sinai Hospital?
Yes.
In that area, right?
One of the injuries points at Mount Sinai Hospital.
Okay. Did you pull the did you serve a subpoena for the medical records from Mount Sinai Hospital?
I did not.
Do you know if the state executed a subpoena for those medical records?
I don't know.
Do we know for a fact if that's where he was treated at Mount Sinai?
I mean, it pings right on top of Mount Sinai, so, and he was in the bed, and the picture shows that he's in a medical bed.
Right. I mean, I'm just trying to figure it out.
There's no other hospital there.
It could be an urgent care maybe in that area.
Is the defense fishing here? And I'm kind of wondering if the prosecution, the police, didn't get Christian's medical records from that date.
Now, you mentioned in those photos that Christian has raccoon eyes.
Yes.
And what is that to you? Dark circles in his eyes?
Yes.
Doesn't necessarily mean he was punched in the eye, does it?
Well, compared to
Objection, speculation.
he already has a laceration to the bottom of the lip and injuries to his face, so it's consistent with getting hit multiple times and also slashed in the face.
All right, detective, you can't say one way or the other whether those dark circles are from a physical contact or maybe he hadn't slept for a long time, right?
Definitely not that he hasn't slept in a long time. They're definitely injuries.
Do you know that Christian and Courtney were up at all times of the night? I mean, they were living kind of a party lifestyle, wouldn't you agree?
Objection.
So the defense is going to actually gaslight the jury. Now we know.
There was drugs involved, correct?
Yes.
There's some text messages talk about Christian using cocaine with Courtney.
Yes.
The crime scene responding to detective is part of crime scene responding to the apartment where this incident occurred, they also photographed certain items that had some type of evidentiary value, correct?
Yes.
And part of what they photographed were letters written from Christian to Courtney, correct?
Yes.
And in your assessment of those letters, would you say that those letters are an acknowledgement of his abuse of Courtney?
I can't remember.
Again, characterization, acknowledgement of, he uses the A word. I don't know that that's what he said. And we went over the letter, and I won't belabor all the points here, but that letter looks like somebody taking the blame, somebody who is trying real hard to be good enough and can never make the grade. What's your sign is saying, I don't think these texts come across the way he wants them to.
Speculation, past evidence, evidence.
Did you see those photos?
I did.
Did you read them? Well,
I
did you
did.
read the wording contained in those photos?
I read them.
Okay. If you look up on the screen, Defendant's Exhibit E, looks like this letter was torn up at some point. Is this what I'm talking about? The photographs of the letters?
Yes.
And there's highlighted sections in there, correct?
Several objections from the overseer.
Why is Courtney sitting up so straight like that? It's like she's posing.
Recapping, so there were some letters that were photographed and retained as evidence by your department, correct?
Yes.
And as the lead homicide investigator in this case, I'm sure you reviewed that evidence, correct?
Yes.
And do you recall these letters?
Yes.
Okay. And so Defense Exhibit E is what the government provided to us, that you seized, the department seized. And part of the letters, although it's ripped, says that he's guilty of gaslighting her, right? And mentally abusing her, right? Those are the...
Just want to point out again, nobody who gaslights is ever going to admit that they gaslight. They would gaslight you into believing maybe you were the gaslighter. They're not admitting that. But, the defense is going to use it and milk it for all it's worth and spin it however they can.
The words contained in this document?
I can't remember, so I don't feel comfortable answering that.
Okay, that's fair enough. Were you able to determine that these letters were written by Umlumseli to Courtney?
Again, I can't remember. I read them that one time, and then that was months ago.
Katrina is saying it's sad because Christian had no idea that he would never measure up because she would never allow it. And that's true. And you see that often. Oh, and one more thing about his use of the word abuse and his admissions that he is causing her some sort of hurt or pain, that he is creating the problem. He doesn't describe a behavior, right? He doesn't say, I did XYZ, right? He said he's describing a characterization of what she's telling him that he did. So he's accepting that blame. And we don't know what she terms ABUSE. It could be you used a bad tone with me. Remember that? She was upset with him because she didn't like his tone. Oh, Martha says she started killing him on the outside a long time ago. It was only a matter of time before she did him physical harm. Yes. Thank you, Martha, for the comment. What a way to say that. Well worded. That's exactly it. They do. They tear you down mentally and emotionally, spiritually, socially. They tear you down in every way possible first so that you're helpless. It makes it really tough to leave. It makes it tough to think. They change your reality.
I'll move on. The court has these. The witness indicated he has no memory, so I'll move on, Judge. I apologize. By Umbrum's recordings that were made by Umbrumcelli, where Courtney can be heard screaming, right?
Yes.
And it's actually, we mentioned it as video, but it's a video file, but it's actually just audio, correct?
No, I think
Except for one that's in the lobby.
I think they're all video.
Well, they're video files, but there's actually no video because the phone is secreted on...
Well, if you watch carefully, at one point he does take out the phone, and then you can see the defendant on the floor screaming.
Okay, the point of it is, the bulk of it is just audio, right?
Okay, yes.
Okay. Now, the person who recorded that is who?
The victim.
Mr. Umbrumcelli, right?
Yes.
He knows he's being recorded, right?
Yes.
If you know you're being recorded, you're going to say kind of, what you want to say, right?
Objection calls for speculation.
That person has an advantage to know they're being recorded, correct?
Yes.
You don't know what happened before that recording took place.
No.
You don't know what happened after that recording took place.
No.
And that's true for the several recordings that are part of the evidence in this case, right?
Yes.
As part of the documentation that you pulled from the One Paraiso this management company, you said you were provided incident reports, correct?
Say that again?
The One Paraiso subpoena returned a bunch of incident reports, correct?
Yes.
And you said there was like a lot of them, right?
Yes.
Those are not your words, those are mine, but there was a lot, right?
Yes.
Too many, I think you said.
Too many.
Right? Which shows a history of some kind of domestic issues going on, correct?
Yes.
And one of those, again, was the body-worn camera from April 1st, 2022, correct?
Yes.
And where Courtney asked for a restraining order, correct?
Yes.
And in that same video, right, one of the officers asks her if he's been violent with her in the past, correct?
I can't remember.
Okay, well, we'll move on. It's been admitted as an exhibit to the court. Now, you mentioned something about Christian's fob was 01027 and Courtney's fob was 01058. Is that correct?
Yes.
And at some point, clearly, I think you testified that her fob became inactive in March of 2022, correct?
Yes.
Okay. You don't know when she lost that fob, do you?
No.
Now, the day of the elevator video, you don't know if she had her fob on her, correct?
Correct.
She might have left it upstairs, correct?
Yes.
Now, you mentioned you served subpoenas on Courtney's for her financial records on some banks. Is that correct?
Yes.
Now, I think you testified it was $2 million.
Yeah, just
Is it
over 2 million.
it's over 2 million? It's not over 1.3 million?
No, I remember the total between both wire transfers. It equaled over 2 million.
You sure?
I believe so. Yes.
Do you want to review anything before you say that that's your final answer?
No.
Okay. Now, the state talks about your efforts to locate Miss Clenney,
Yes.
right? You remember testifying about those efforts?
Yes.
Right. You actually traveled to Hawaii, right? When you found out she was there.
Yes.
So you got a free trip to Hawaii.
Yes.
Paid for, the city of Miami paid for that, right?
Yes.
Judge,
So, before you decided to fly to Hawaii to effectuate the arrest of Ms. Clenney, did you lose your phone?
No.
So you had my contact information, correct?
Yes.
You never called me and said, "Hey, Frank, you know, look, things have, changed and we want to surrender Ms. Clenney," right?
Oh boy. Really? He's going there? So he characterizes it as a free trip to Hawaii. Okay, it's not like the guy was hanging out on the beach. I mean, the boss is going to be tracking what's going on. And I think where he's going to go is, hey, you didn't need to go to Hawaii. You could have just called me and I would have had my client turn herself in. Because earlier in this hearing, this lawyer had got this witness to say, oh, yeah, you were cooperative. Oh, yeah, I had your phone number. So he wants to make it sound like it was unnecessary for the police to go get her. Well, no matter how well-intentioned a lawyer is or how honest he is, the client makes decisions. So if this lawyer phones her up in Hawaii and says, yeah, the police want you to turn yourself in, you're going to be arrested. She's in Hawaii. She's got money. She can work anywhere in the world. She's a spoiled brat. I mean, the lawyer can't guarantee that she's going to return to the jurisdiction or turn herself in or anything else. He can't look straight-faced and guarantee that unless he goes and gets her himself. In which case, still, if she wants to take a runner, he can't physically stop her. So I don't think that it's any big deal that the police went and got her. It seems reasonable. If they hadn't gone and get her, and she did take off, everybody'd be asking the question, really, why aren't they going to get her? Don't they care?
objection relevant.
Say that again.
You never called me and said, "Hey, listen, things have changed. Bring in your client."
No.
No? Instead, you enlisted the U.S. Marshals to go get Courtney out of Hilo, Hawaii. And do you know where she was in Hilo, Hawaii?
She was in a rehab facility.
In a medical rehabilitation facility, right?
Objection, testify.
She didn't flee to Hawaii, correct?
Objection. Actually, you know what? I will withdraw.
Yes. I mean, what was the question? Sorry.
Did you think she fled to Hawaii?
No.
She was there to get help, right?
Yes.
Did you speak with her
Yes.
when you were in Hawaii?
Yes.
Did you tell her that you thought your investigation was closed? You're under oath, detective.
If I thought that she was under,
Did you tell her that this case had been closed by you?
that I was closed?
Yes, sir.
No.
And again, just talking about the phase 2 issues, I do.
That's interesting to me, why the lawyer is asking this particular question. And it makes me wonder if Courtney told the lawyer something to this effect. There's something here. I just don't know what all the facts are. I suppose it's going to come out in trial. Unless someone in the chat has other ideas. Or if you know something.
You recall me staying in contact with you, maybe every couple of weeks or 3 weeks to a month I would contact you, correct?
Yes.
Judge,
Now, talk.
more counsel needs to ask a question and get an answer.
Now, in reviewing the financial records, right, you're just reviewing the documents, correct?
Yes.
Do you know why she transferred those monies into her father's account?
No.
Do you know how much she currently has in her accounts?
Right now, no.
Yes.
Right now, no.
At the when you got the subpoena returned, when was that?
I can't remember the exact date.
And what was the balance in her accounts? at
I
that
believe it was about $4,000.
Yes, Judge. One very brief matter for the sidebar.
Sidebar.
If it's just attached, which one? If it pleases the court, as discussed, sidebar, the state provided the clerk an exhibit to just attach, which would include exhibit 33, which is an Instagram live video. Detective, I want to pick up a little bit where Mr. Prieto left off, and he discussed with you about not contacting him when a decision to arrest was made. When was your arrest warrant signed, if you remember?
I don't remember the exact date.
Would the warrant refresh your recollection?
Yes,
Okay, do you have a copy of it?
I do.
Give me 1 second. Do you have a copy of the warrant? The last page of the warrant. When was that warrant signed?
August 4th,
Okay.
2022.
You remember when the defendant was arrested?
Yeah, yeah, it was like a week later.
Okay. This warrant was obtained under seal. Do you recall that?
Yes.
Okay. Do you recall why it was obtained under seal?
So no hints would be given to the defendant, and then they would flee again,
Was
or
you-
flee anywhere else.
Okay, so you said flee again, or anywhere else.
Yes.
So I want to parse that out because Mr. Prieto asked you the question.
Objection, counsel's testifying.
Mr. Prieto on cross-examination asked you the question, did you believe the defendant fled to Hawaii? Your initial answer was yes. He then asked you again in a different way. You said no, and then he asked you about rehab. So I want to redirect you as to that conversation. In the context of the defendant being in a rehab facility, you don't have any reason to doubt that she was there for some kind of help.
Correct.
Okay. Do you agree that it's simultaneously true that she could have fled there?
Possibly yes.
Okay. Was that a concern?
I'd be with the defense on this one. Yeah, I could see him thinking, like, is he a cop? Thinking, yeah, okay, she's fled. She's just trying to avoid the jurisdiction, just be away. But she was not under any court order. There was no legal requirement for her to remain in Miami. So she can go wherever she wants unless the court tells her otherwise. So technically, she's not really fleeing.
Concern and why you did not contact Mr. Prieto.
Yes.
You've been in homicide and robbery
Yes.
units. You would agree that those units are highly investigated?
Yes.
In the context of those investigative units, does the city of Miami do everything by themselves, or do they rely on the prosecutor's office?
We rely on prosecutors as well.
And that's true for review of search warrants, subpoenas, and particularly arrest warrants.
Yes.
Okay. So let's walk through that. In the nature of a homicide investigation, how many have you participated where there have been an arrest?
Currently,
I'm talking about participating, so if you
No.
assisted as robbery or anything else.
oh, in robbery too.
Yeah, all homicide
Oh.
investigations that you've ever assisted on, how many have been an
On
arrest?
homicide alone, about 6. That have 6 or 7 that have been no. About 8 with that have made an arrest, and then in robbery, probably over 100.
And how many of those has the defendant asked to surrender themselves? It's redirect. It's redirect.
None.
No. Is a homicide a dangerous crime?
Yes.
In dangerous crimes, how do police approach the apprehension of a subject in that case?
As safe as possible,
Why is that?
because a lot of the times they know that they're going to spend the rest of their life in jail, so they'll take any action to not go to jail.
Mr. Prieto discussed with you regarding quote unquote cooperating with the investigation. Do you recall that?
Yes.
Okay. In this case, you mentioned that you obtained cell phones and did search warrants on those.
Yes.
For Ms. Clenney, how many phones did you obtain?
2.
Okay. How many warrants did you execute?
2.
At any point in time was the defense counsel contacted about the passwords to search those devices?
No.
They were not? At no point in time the defense has offered to or was contacted?
No.
In September of this year, the defense was not contacted for the
The defense lawyer doesn't like it. Defense lawyer played a game. He played a dirty game. And now the prosecution is going, oh, okay. I play this game with you. And he doesn't like it one bit. That's funny.
Did the defense ever provide the pen for the phone?
No.
Have you been able to answer her phone?
No.
What efforts have been expended in attempting to answer her phone?
We have taken the phone to the Secret Service, and they have attempted to do what is called a brute force to be able to get into the phone.
With regards to the cases that the defendant has, one of which was the Las Vegas case, Mr. Prieto asked you about the posture of that case, and more specifically, whether it's been dropped or prosecuted or outstanding. Do you remember that?
Yes.
Okay. The Las Vegas case, you said it was dropped.
Yes.
The victim in that case and sole witness was the victim in this case,
Yes.
and that's now a deceased person.
Yes.
In the context of that letter, which you saw and the one time you reviewed it, was there any documentation of physical abuse by?
I'm sorry. Can you repeat that one more time?
Sure. In the letter that the defense showed on the screen,
Yes.
that was torn in the middle, missing a chunk. Do you know what Christian Omuselli's writing looks like?
No.
Do you know if that was him that wrote that letter?
No.
It was certainly signed by a Christian Omuselli.
I can't remember if it was signed or not, but
So you don't know if he wrote it.
I don't.
You don't know if the defendant wrote it.
No.
You don't know the context of that letter.
That I remember, no.
That letter itself did not document any incidents of physical abuse.
I don't remember.
Let's talk about some of the messages that Mr. Prieto discussed with you. He mentioned the October 9th, 10th, and 11th sequence of messages. And specifically, he showed the screen message where it says, "Tell them exactly what happened." Do you remember that?
Yes.
Was that a threat?
Objection calls for speculation.
In what context was that message given?
Objection calls for speculation.
I'm going to pause here because people are asking about the letter that Christian wrote. So the prosecution just went through this whole thing. Do you know if she wrote it or if he wrote it, blah, blah, blah. He wrote it, right? But somebody's asking, oh, maybe Courtney Clenney typed it. So I should let you know that when I reviewed the letter, I reviewed a typewritten copy, but the original letter was not typed. It was handwritten.
The message, "Tell them exactly what happened." What occurred immediately before that message and immediately after that message?
I would have to see the messages. I can't really remember right now off the top of my head.
Sure, I'll just direct support. The January 30th messages Mr. Prieto put on screen, the first message was said something to the effect about, "This will give you time to think about your actions," and then a second message shortly after it said, "Enjoy the hospital."
Yes.
That was the first message. "Think about your actions" was the first message after that time break you were talking about earlier?
Yes.
Okay, so there was the argument that was documented over the overtime of the football game.
Yes.
There was a break in time. I'm not trying to offer anything, so tell me if I'm wrong here. I'm just trying to understand your testimony. There was the argument, time break, and then the first message was, "Tell them, think about your actions and enjoy the hospital."
Yes.
Okay. The defendant, like Mr. Prieto showed on screen, wrote LMAO. What does LMAO mean?
Laughing my ass off.
Okay, so the defendant was mocking the victim.
Objection calls for speculation.
Isn't it funny that when the prosecution does this, the defense objects, but when the defense does it, the defense seems to think that's just fine.
Did you read all of those messages, like beginning to end and all of them?
I did.
Okay, so in the context of processing those messages in those contexts,
Yes.
is the defendant mocking the victim?
Objection calls for speculation.
You can opine.
Yes.
Mr. Prieto asked you about your ability to identify victims of domestic violence. So I want to talk about that. Victims of domestic violence, do they often cover for their abusers?
Yes.
Mr. Prieto, you're going to ask you about the Las Vegas incident where Ms. Clenney at the end said, "Well, I didn't tell you everything." Right?
Yes.
Okay. So is it uncommon for a victim of an aggravated battery to not tell the hospital what caused it?
Objection, Judge.
Redirecting. When you saw the body camera of the Las Vegas incident, the officer, before kind of really anything, went straight to Mr. Lumbaselli and read him his Miranda rights, right?
Yes.
Okay. Is it uncommon for males to be perceived as the aggressor in domestic violence incidents?
It's not uncommon.
As a police officer yourself, is that often who you perceive to be the subject or the culpable party?
Yes.
Okay. Was that the case here?
Oh, good question. Good question. And good on this detective for answering yes. As a police officer, Is that generally who you would expect or who you would see as the primary aggressor? And if you're telling the truth, you're going to say yes. Because the fact is that it is that way more of the time than it is the other way. But good on him for admitting it. He's not getting into his ego here and saying, oh, no, I have no subconscious bias whatsoever. I'm not prone or subject to, implicit bias or stereotypes or anything else because I'm above all that. No, he just said yes. So good for him. That's the way to testify right there. And by the way, I think some of his I don't remember and some of his struggling here, I think this guy is in physical pain. And it might be affecting how he's handling everything.
Yes.
Such as in Las Vegas, where there was further investigation revealed the defendant was the aggressor. Is that what happened here?
Yes.
And let's talk about how you got there. The arrest warrant. You said you've worked on 8 homicide cases. How many have been arrests in homicide cases? How many of those arrests were yours?
7 of them.
Okay. And on those, how many did you apply for arrest warrants?
Maybe 6 of those.
In those contexts, is the state heavily involved in the writing of the arrest warrant?
Say that again?
Is the state heavily involved in the writing of an arrest warrant?
Yes.
Initially, for example, you perceived this to be a justifiable use of force before you got everything else.
Yes.
As part of your initial perception, is that the final call on that prosecution?
No.
Okay. What happens in a homicide investigation where you pursue an arrest warrant?
I have to sit with the state attorney's office and we have to go through everything that has been found in the case to come to a conclusion.
Are you directed by the state to pursue investigative steps?
Yes.
As part of being directed by the state attorney's office to pursue investigative steps, does that include subpoenas?
Yes.
Can you write a subpoena?
No.
Can you issue a subpoena?
No.
Who do you need to issue a subpoena?
I need the state attorney's office.
I want to address something I'm seeing in the chat because I know the issue can often turn into a debate. And that is that we don't know the statistics of male victims of DV. Well, yeah, that's true because they don't report. We also don't know the statistics, the true statistics of how many SAs there really are, how many things involving kids there are, how many male to female DV there is. So when I talk about statistics, I'm talking about known statistics. Because if you want to discuss the unknown, well, we could go down all kinds of rabbit holes and be here for a long time. So I just kind of wanted to stop any potential, derailing on that issue. Not that, and I'm not, to the person who made the comment, I am not invalidating your comment at all. It's true that there is lots that goes on that we don't know about.
Let's talk about Ms. Clenney's, the defendant's statement to you. Mr. Prieto asked you, and essentially she outlined 3 iterations of the incident. Do you recall that?
Yes.
Okay. And he tried to focus in on the part of the warrant where it said that there was inconsistencies throughout. So I want to go through that. The defendant keeps, iteration 1, 2, and 3.
Yes.
In iteration, for example, 2, did she give more or less details than in iteration 1?
On 2, she gave more.
Okay. So even though she told you a story for statement 1. She told you a bigger, more sensational story, statement 2.
Objection, Judge.
I'm just,
Counsel's testifying defense on that.
was the second statement, because you said it was more details, was it more or less sensational than statement 1?
More.
Okay. So, in that context, is her statement 1 consistent with her statement 2?
No,
Okay. Why not?
because she's adding more to the story.
Okay. Why does it matter that she's adding more to the story?
Because it helps us out, helps us come to a better conclusion of what actually did occur, and it's filling in the gaps of the story.
And then statement 3 was that last recap where she takes a moment and talks to herself, right?
Yes.
So let's process through that. That one, that third statement, was she speaking faster or slower than her 2 prior statements?
I can't remember.
Okay. Was she kind of rushing through it, or, I mean, what I'm trying to figure out is, did she give more details on statement 3 than statement 2?
I want to say she was rushing through it because she was, I guess, getting annoyed that I kept asking her for the story again and again.
Why did you?
I want to comment here on some distinctions or some nuances in looking at statements and inconsistencies. It is normal for a witness statement to include a few more details later. What we tell people, witnesses, is listen, thank you for your statement. Here's my card. If there's anything you remember later and you want to add things, then you can add. But what I also tell people is you can add to your story. You can't subtract from it. So once you say something, it's said. So it is normal to go home, think about it, and think, oh yeah, I forgot to tell them this, or maybe that's important, or have something come to you while you've had, a chance to calm down. What matters is, as the prosecution is asking the question, what kind of details? Were they sensational details? Were they self-serving details? Were they corrective details that came out of the questions? Like Sarah Boone, for example, telling her stories and then realizing after listening to the back and forth happening in court that she had to come up with an overt act, and boom, all of a sudden there's an overt act. So the fact that there are more details, that fact alone isn't enough to say that the person is lying. It depends on what and why and when. And he is asking about cadence. And I find that interesting too, because you don't often hear prosecutors talk like that.
You keep asking her for the story over and over again.
Because sometimes the more that we ask the story again, something clicks to mind, and they remember a new detail.
And so you weren't essentially trying to trip her up. You were just trying to get trigger and remember. Okay. That third iteration, was it the same as 1 and 2?
I can't really remember too well.
I guess my point is, in every iteration, she told the story that she was grabbed by the neck, pushed against the wall, and then down. Got up, got a knife, and stabbed Christian.
Yes.
Or threw a knife at Christian.
Yes.
But each one of the 3 accounts were different.
Yes.
How we got there, I guess, is different.
Yeah.
The manner in which the defendant described in her statement being grabbed at the neck, forced against the wall, thrust to the ground, as Mr. Prieto was testifying, did you see any injuries on her that would corroborate any of it?
No.
We talked about the Instagram video ourselves, and Mr. Prieto showed a abrasion on her right shoulder, almost by the bra strap, and press, like a circle on her wrists and her arms.
Yes.
In reviewing the Instagram video, did you see those bruises?
Yes.
So they predated the stabbing.
Yes.
There were these neighbors that Mr. Prieto discussed, and they provided the statement that you interviewed. One talked about running around a car, and one talked about an incident at a dog park. Do you recall speaking with Mr. Prieto about those?
Yes.
So let's talk about it. The person that's talked about running around the car, did that person tell you they saw what led to and what happened after that incident?
No.
Did that person understand the context at all, or tell you what the context at all was of that?
He assumed that he was trying to pull it out of the car.
Okay, but he didn't tell you beginning, middle, end.
No.
Dog park incident. That individual, did he tell you beginning, middle, end in the context of the incident?
No.
So I asked you those questions in the lead up to the surveillance video from February 21st. An individual that would see part of that video, that would be an individual who would say Christian is striking Courtney.
Yes.
Without seeing the defendant walk into the elevator, holding the door, and then attacking him beforehand, they are lacking context?
Yes.
Okay. As part of the search of the apartment, documents with the victims' names were obtained. And I'm bringing that up in the context of Mr. Prieto talking about the lease and who was on the lease. Are you aware that Mr. Omuselli is listed as a permitted occupant of that apartment?
Objection, reading.
I'm asking if he's aware that that is. You can answer.
Yes.
Okay. Is he a permitted person to enter?
Would I be able to look at the?
Yeah, you can look at your, if you have the lease.
Christian of Umsali.
Was he?
Yes.
Okay. As part of the documents obtained as part of the crime scene documenting the scene, at any point in time did Miami Police locate an electric bill?
Sorry, say that one more
At
time.
any point in time did City of Miami locate an electric bill in the name of Christian Muselli?
I can't remember.
Okay. If it did, it would be in the crime scene photos?
Yes.
Okay. When you went through, did you locate clothing belonging to a male?
Yes.
Did you locate his belongings?
Yes.
Mr. Prieto was discussing with you the defendant having, quote unquote, kicked him out. As a fellow tenant of that unit, would she have been legally?
Objection, Judge, calls for legal conclusion.
Did she let him back in April 1st?
Yes.
Did she let him back in April 2nd?
Yes.
Did she let him back in April 3rd?
Yes.
West Coast is asking, is he on the lease? The answer is no, but he is listed as a permitted occupant. Also, whether or not he's on the lease is not really the point. The point is, did he have a right to be there? And the defense want to make it sound like he was sponging off her and he was just there when she didn't want him and all this. That's how he wants to make it seem. But the prosecution is now bringing out points like, oh, there was an electric bill there in his name. His clothing was there. His belongings were there. He lived there and he had a right to be there.
Mr. Prieto asked about or discussed with you body-worn camera from an April 1st incident. So I want to talk to you about that. Have you reviewed that body camera?
I did, but I don't remember too much from it.
That's fair. Do you recall a conversation about a restraining order?
Yes.
Okay. Do you recall the defendant making a statement that she needed to get a restraining order before the victim got it?
I remember the restraining order part, but that's it.
And I'll just direct the court to that. Do you recall a police officer asking the defendant whether she was under the influence of alcohol or controlled substances?
I don't remember.
Okay, I'll direct the court to that. Do you recall whether the police instructed her as to the circumstances in which of how to obtain a restraining order?
Yes.
And did the defendant state anything that would have justified the issuance of a restraining order?
I'm sorry, I didn't hear you.
Did the defendant say anything that would have justified the restraining order?
I don't remember.
Objection, Judge. Cause for legal conclusion.
Mr. Prate discussed with you regarding clumps of hair in the Las Vegas incident. So I want to walk through that with you. Do you know whether that was human hair or extensions?
I don't.
Do you know whether the defendant took them off herself or whether they were ripped off?
I don't.
Did, in the video, did the defendant's hair appear to be disheveled?
Yes.
Okay. Did it appear to be yanked, like missing patches?
No.
So you don't know how the quote-unquote hair, clumps of hair got anywhere?
I don't.
Now, Mr. Prieto discussed with you about blood at the apartment and specifically said the words that the droplets of blood was consistent with running around the apartment. Do you recall that?
Yes.
Okay, so since Mr. Prieto asked that, I'm going to redirect you as to that conversation. We discussed ourselves 1, 2, and 3 bloods. 2 were clumps. 1 was where the 2 guest bedrooms interlock.
Yes.
And the defendant was found cradling the victim. The second was a little bit further into that.
Yes.
Right, okay. So then the droplets of blood, where was that?
It led from the second pool of blood to the master bedroom and bathroom.
Okay. Through the kitchen?
Yes.
Okay. So because that pool of blood that we discussed was number 2, where the defendant was found, or the defendant and the victim were found, that was the conclusion of the droplet. Was that the conclusion of the droplet trail?
I'm sorry, can you start over?
Since we know that the victim and defendant were found at that second pool that we discussed.
Yes.
Is your testimony that the droplets, because it was running around the apartment, that was the conclusion of the droplets of blood throughout the apartment?
Yes.
Okay. And more specifically, the droplets of blood begin in the kitchen, go to the master bedroom, back through to that second pool?
Yes.
Just want to point out that if, as the defense wanted to characterize it, somebody was running through the place while bleeding, you can tell by the way the blood droplets land. So a blood stain pattern analysis could be very useful in this case.
As it pertains to the calls, Mr. Prieto brought up how the defendant called 911. Do you remember that?
How, on which one?
How the defendant called 911 when Christian was stabbed?
Yes.
Okay. So, and we know that Mrs. Clenney, the defendant's mother, was on the phone with the defendant at the time of the stabbing, specifically the first call.
Yes.
Mr. Prieto made a very long conversation about how you didn't ask about the second call.
Objection, Judge.
But we'll get to that. So, as it pertains to the stabbing incident having occurred during the first call, that first call was for 6 minutes at 2:43. Is that
Yes.
right? Okay. So, Mr. Ombuselli was stabbed somewhere between 2:43 and 2:49.
Yes.
Okay. The defendant's first call after the stabbing, do you recall who it was to?
To her mother.
Okay.
Her mother.
How long was that call?
I believe it was about 7 minutes.
Okay. And then after those 7 minutes passed, did she call 911 or did she call someone else before?
I can't remember.
Okay. I'll direct the court to the records. And then she called 911.
Yes.
So, in a nutshell, she waited 10 minutes before she called 911.
Yes.
Objection, Judge. It's facts, not in evidence.
I'm eliciting the fact to be in evidence.
I just want to address some things happening in the chat. People are talking about the detective's body language. Somebody's saying, "Oh, he's got his arms crossed. It means he's defensive." No, that is not. There's no rule like that. That's not what it means. Arms crossed could mean you're more comfortable that way. It also appears that he has back pain, and I know sometimes I do, and I will cross my arms and kind of pull my shoulders forward to try and stretch out those muscles. Could be that. Could be cold. He could be tired. There are a lot of reasons why people take that posture. It does not automatically mean defense. Also notice, he's not got his fists like covering here. It's just sort of a relaxed pose. So I don't think that really means anything. And as to when these phone calls were made in relation to when the crime occurred, I think that I think you could take the same set of facts and argue them two different ways, depending on whose side you're on, defense or prosecution.
So let's discuss your conversation with Mrs. Clenney. And the court has the audio recording of it. But I want to kind of reverse do it. When we talked earlier, I asked you whether you knew anyone else was listening on the call, and you told me no.
Correct.
Did you find out whether someone else was listening on that call?
Yes.
Okay, who was that person?
Her father.
Okay. When the father interjected earlier, you said that the father interjected to say that Mr. Prieto was at the police station.
Yes.
Okay. That was essentially the first time where you became aware of the lawyer and everything else.
Yes.
Judge, this is, I'll object, this is outside the scope of my cross.
It's literally redirect. So at that point, when you got up and left to go let Mr. Prieto into the police department, that ceased your interview with Mrs. Clenney.
Yes.
When you interview witnesses, do you interview them together or separately?
Separately.
Why do you do that?
So they don't share information with each other, and we can get two different understandings of their side of the story.
So, not having known that Mr. Clenney was on the other line of that phone, you don't know whether he was feeding her answers or not.
Correct.
Separate from that, now knowing that Mr. Clenney was listening in on the conversation, did you have any reason to further elicit any testimony from Mrs. Clenney?
No.
Now, let's talk about the two calls. Did you ask explicitly about the first call?
Yes.
Okay. Did Ms. Clenney answer your questions?
Yes.
Okay. At any point did she go on a tangent?
Objection on relevance.
Sure. While talking about the incident that happened April 3rd, at any point in time did she stop talking about the April 3rd incident and start talking about the week prior?
Yes.
Okay. At any point in time after talking about how terrible the victim was, did she ever return to the date of incident?
No.
Okay. So Ms. Clenney not only didn't discuss the second call, but then she redirected
Yes.
to a separate incident. Okay. Can the defense put on the text messages? The text messages that you showed from Mrs. Clenney?
The one
Put them on?
Yeah.
Yeah. Exhibit C are the screenshot of the text messages, right?
Yes.
And Mr. Prieto discussed with you how 404 is just because they were screenshotted Central Time and so on and so forth. So, what time was police called?
I don't remember that time right now.
Would you agree it was before 5?
Yeah.
Okay. So, all of these text messages were sent.
That's interesting. He was able to describe that earlier today, but right in this moment, he doesn't remember. I think that he has some sort of pain happening, and it really is interfering with his thinking or maybe contributing to brain fog. People with chronic pain can tell you that it really does impact their ability to remember, to think, that sort of thing. So I don't think he's being lackadaisical or hiding something. I think he's struggling sitting there. I mean, physically.
After stabbing?
Well, I can't really tell.
Well, the first message 4:04 p.m.
Yeah.
Do you have an iPhone?
Yes.
Okay, so do the messages kind of load reverse chronologically?
Yeah. Yeah.
Okay, so you agree that these messages were sent after the stab?
Yes.
You've reviewed the body camera in the case, yes?
Yes.
When the officer that first arrives and renders aid, what does he do to Miss Clenney?
He separates her from the victim.
Is she put in custody?
She's detained.
Yeah. Does she handcuff the victim?
Yes.
Okay, so did she have access to her device?
No.
Okay. So when Mrs. Clenney sends this message, please tell me what is happening, asking the defendant what is happening, the defendant would be unable to reply.
Correct.
Okay. So Mrs. Clenney, not knowing what happened and demanding that the defendant call her, then said, even though it was self-defense, don't say anything with the police without getting a lawyer first. That's what's in Defense Exhibit G.
Yes.
But that wasn't the message that you saw, right?
No.
The message you saw was the last one?
Yes.
The last message says, before it cuts off here at the bottom, it is very important, ... Even though it was self-defense, you cannot say anything without an attorney exclamation point. Innocent people get in trouble all the time, right?
Yes.
Is that offering the defendant self-defense?
Objection, Judge, speculation.
How is that speculation? How is that speculation? That is what the text says.
So I want to talk to you about why you didn't talk to Mrs. Clenney and Mr. Clenney any further. After your investigation, et cetera, then you briefed the state, and that's where we were at. At some point, did you realize that Mrs. Clenney's statement was kind of inconsistent with everything we talked about?
Yes.
Okay. Would her further statement have contributed anything either positively or negatively in your investigation?
No.
Okay. Why not?
Because she might want to make up any more excuses or change something she says.
I'm asking because defense counsel crossed on the issue, and I'm asking him why he didn't do something in the investigation. So if counsel's going to make the lack of evidence argument, I can leave that.
Right, so just answer the question as to why didn't call her?
Why didn't you interview Mrs. Clenney?
Because I didn't know if they were going to try and make up a new story or change anything from that date of incident.
What about Mr. Clenney? Is that the same answer, I suppose?
Yeah, pretty much.
Objection, pleading.
Okay.
Why not Mr. Clenney?
About the same answer.
Neither, on cross, Mr. Prieto asked you about where Mrs. Clenney and Mr. Clenney were in relation to the defendant. And if I recall correctly, you said that they were in Texas and she was here.
Yes.
Were they witnesses to this incident?
No.
So they do not know what happened inside their apartment.
Correct.
No further questions.
the defendant was making. I'm still a little bit confused about that. You said facts on evidence. I have a follow-up. Let me just make sure that I'm putting it all together correctly, so.
Sure. 1 second. Detective, I'm going to ask you to step down. Just to get through the screen.
Let's watch see if he walks funny too, in respect to pain. But it's interesting here. The judge is saying she has questions about this 911 call because of the objection that he made. He said, "Oh, facts not in evidence," and the judge is saying, "Well, I thought we had these facts." So now they're gonna have to clarify that. But I think she's calling the lawyer on the game very subtly.
And then you have questions about this, is correct?
Yeah, he looked pretty stiff, don't you think?
After deploying on the flash drive into the 16 thinking within the flash drive. Do you know what all of these columns mean? Okay, will you tell the court what these columns mean?
This is the number that was called. This is the phone call was changed from. This is the date and time of when it was made.
Okay. And this is not Eastern Standard Time?
Correct.
What time is that?
It's UTC.
In April, how many hours ahead of time is that?
4.
Okay. I mean ahead, so that it's 0 time. Minus.
Yes.
Okay. So this first column, 4/3/2022, 146, that actually, if I'm understanding correctly, is April 2nd, 2022, 9:46. So I want to direct you to the one that sticks up here is 911. Do you see that?
Yes.
Okay, so that's the first 911 is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 is the 17th and 18th slide I'm calling to. Do you see that?
Yes.
Okay. What time is the 911 call?
2057, which would put it back to 427.
With 1657.
Yeah, 1657.
So immediately before that, the defendant dialed this number 76-472-8232.
Yes.
And that was an 18-second call.
Yes.
Do you know who that was with?
I do.
Okay. Do you know if that was one of our recently?
It could be.
Right before that, there is 2 separate calls. We see here one's 437 and one's 393. And then the defendant's number called 512-417-3408. Who was that? With that number called?
That is the reason.
Okay. So, again, 2 calls. One's 393, one was 430. Let's talk about the first one. The first one was at 20:43. What time is that? 9 and 10.
That is 640.
Okay, which is what?
It's 440.
Okay. So then there was 6 minutes, and then the next call was again to the defendant's mother for 4:30.
Yes.
Okay. As an aside, do you have multiple calls on that once?
Yeah.
So would that explain why there's kind of extra calls overlapping?
Yes.
Right before these 2 calls, there are 1, 2, 3, 4. There were 1, 2, 3, 4. Yeah, 4 calls from 512-745-3582 to 214-789-9531. Do you see that?
Yes.
Okay. Whose number is 214-789-9531?
I believe that was the victim's call.
Okay. And then, so let's go from oldest to youngest. The first call in that chain is 1955. What time is that local time? 3:13? No, sorry. Okay. So 15:55 is what time? Okay. So 15:55 is 3:55 local time. Is that the same time when Mr. Musella getting the elevator?
Yes.
So the defendant is calling the victim, and he's not answering. The defendant does that one more time, exact same minute. Do you agree? Okay. And then again 6 minutes later. Okay. And then finally at 20:33, he does get another call. This one's answered. This one's answered. Okay. And then 5 or 3 being okay.
So Courtney's calling him and calling him and calling him while he's on his way up. Almost like, hurry up and get here. Interesting.
Just for the record, I'm sorry, I keep interrupting you. What does it mean?
It means that there was a call was placed, but hung up.
So, just I guess put a pin in it and end it. How much time passed between the first call to mom and the defendant calls them? So 20:43 to 20:57.
11 minutes?
I think math isn't our best option. Would that be 14 minutes?
14 minutes.
Okay. I believe, I don't know if the court wanted me to inquire any more about that.
That is helpful in answering any questions.
Where did that fall?
Oh my gosh, I can't believe I just did that. Just blah, blah, blah without the mic on. Addie is asking why they're going over these call records. And the reason is because the judge asked a question. And the reason the judge asked the question is because the defense objected, saying facts not in evidence, except the facts are in evidence. And so now they have to go through the whole thing and show that. So that's why. And the issue here, I mean, this is pretty critical, is the time that the incident occurred. Very short time window. And the prosecution is alleging, hey, she let him suffer for that many minutes. There was a delay in the 911 call. Now, I'm sure the defense is going to argue that and, take the same set of facts and argue it a different way. I expect that. But that's why.
And so, going back, so the 911 call, and just kind of, without converting the time, I'm going to use the time here, it's a little easier because math is not your strong suit or mine, okay? It says 2057, there was a call from 911.
He just said math is not your strong suit? Wow.
Right? And right before that, there was a call to the 512-745-3582, correct?
Yes.
This column here is the number called, correct?
Yes.
And what is this column here, the CPN?
I can't remember right now.
Well, let me just phrase it this way. There's two calls prior to the call to 911 to 512-745-3582. Is that correct?
Yeah.
So those are calls to Miss Clenney's mother, right?
Yes.
You have no idea when Mr. Maselli received that stabbing, correct?
No.
Prior to the call to 911.
Correct.
You don't know if it was during the first phone call or the second phone call, do you?
Correct.
So that's complete speculation then, for you to say that there was a time lapse of 14 minutes before she called 911, correct?
I don't think so.
Well, let me ask you this. The stabbing could have occurred exactly at 20:57, according to these phone records, correct? Right before the 911 call, that's when the stabbing could have occurred, correct?
It could.
You don't know either way, right?
Well, this is funny because the defense is saying, okay, between this last call with the mother and the 911 call, there's all this time. So the defense is arguing that, well, that's when the incident occurred. Except Courtney says that she was on the phone with her mother when it occurred. So somebody's lying, or more than one person is lying here. And why lie? Why lie? So this defense lawyer can argue it either way, but it's in neither iteration of a story here is it going to be good for Courtney.
No further questions.
I do have very brief redirect. Mr. Prate's a very skilled attorney, and he asked a bunch of questions where you said
Objection.
correct.
Should I cut us off?
No, I'm redirecting him on the very specific point.
The very simple.
Is that sure? So my question to you is this. You don't know, obviously, because you weren't there for the stabbing.
Correct.
The reason that you know that stabbing occurred on the first call is because Mrs. Clenney said that she was on the first call.
Objection, Judge Price. It's legal.
Did Mrs. Clenney discussing the two calls only discuss the first call?
Yes.
And in the context of the first call, she said that the stabbing had occurred at that time, specifically.
Yeah, that didn't happen.
So we know definitively that, according to Mrs. Clenney, the stabbing occurred between 2043 and 2049.
Yes.
So, worst case scenario is 14 minutes from 2043 to 2057. Best case scenario is 8 minutes.
Yes.
So defendant again, before calling 911, called her mother, contacted the building, and then called 911.
Yes.
That's all.
So, the defense is going to base some argument here on these phone calls and the timing, and maybe somebody was mistaken and it didn't happen while she was on the phone, or blah, blah, blah. Who knows how they're going to spin it. But here's the other thing. And a couple of people, I think Frauke and Addie in the chat have brought up the physical evidence at this scene. So the blood stain analysis will show that time had to have passed, not just because he was moving around, but because of coagulation in certain parts of the evidence at the scene. And I can't be too detailed here because YouTube, but the evidence shows it as well. So if you want to argue that it was 6 minutes here or 5 minutes there, if you want to dispute the phone call, the phone log evidence, you've still got to contend with bloodstain pattern analysis. And that is physical evidence. And it doesn't lie.
Right. Thank you both for
As far as the decision
Yes.
So, Judge, I did reach out to the medical examiner. I spoke to him. I also spoke to your judicial assistant. She believes that you have availability for Thursday afternoon at 2 o'clock.
Okay, I think that is the end of this day. There's another whole day of this bond hearing. Just switch screens here and check the chat. Do you guys want to keep going with this bond hearing, or have you had enough of it? What do you want me to do? Because we can keep going with this, or we can skip it. There is some sort of hearing happening, and I don't know what it's for, on, where'd I put it? November 15th, I think. So that's this coming week. I don't know if it's going to be streamed or not. If it is, I'll cover it. So Ada's saying, yes, keep going with the bond hearing. Joan is saying, keep going. Gwen, okay. People are saying, keep going. Okay. I'm not hearing anyone say no. Then again, somebody who doesn't watch probably isn't in the chat at all. Buffy says, I trust you to choose. Oh, don't trust me. I need to know what you want. I'll post things that I think are interesting and nobody else does. So, okay. So we will keep going. So I want to just see what you're thinking about this so far. Do you have any thoughts about what you're hearing? The lawyers? Do you have questions? Anything like that? Iran's asking me, Lori, are you for sure covering this trial? I intend to. I always intend to do things. I intended to cover Adam Fravel's trial, but it wasn't streamed. I wanted to cover other things, but they they clashed with Sarah Boone, and I knew people wanted to see Sarah Boone. So my intention is that I will cover it. That's the plan. But if something way more interesting or way more important comes up and you guys then want to see that other thing, then that's what will happen. I would take a poll, though, if there's a conflict. Oh, Addie is saying, lurkers, here's your chance. Speak up. That's great. Somebody's asking, what interests you most about this case? Are you asking me, or are you asking everybody in the chat? Because I like the question. That's an interesting question. And it would be interesting to me to hear everybody's answers. People watch for different reasons, right? Courtney's saying prosecutor is jumping on a lot of the points we have all made during our previous live sessions. Yeah. Yeah, it's interesting to see some of the things we've been asking addressed. Jenny says, I don't think it's going to be easy for the jury to like the defense attorney. I don't know. Maybe. I don't know. Okay, so the commenter is saying, I'm asking you, Lori, and everyone. Yeah, I'm interested in what everybody thinks. So what interests me? Well, the reason I started covering the case at all is because subscribers and regulars were asking me to. So that's why. And I don't know. I don't know what interests me most. You know what I do find interesting is in the different perceptions that the regular person has watching all of this. That's interesting to me, but I'm interested in sociology and all that kind of stuff. Somebody's saying, yeah, you're invested now, right? Oh, Captain Katie, I'm sorry you're not feeling well. I hope you feel better. I hope it's nothing serious. West Coast is asking, is it possible that Courtney hid his phone from him during that 14-minute gap? Interesting. Was it found on him or somewhere else in the apartment? Very interesting. And there was another incident, the one where she's saying, "Oh yeah, you go ahead and call security," where there was some sort of struggle that involved a phone. It is not uncommon for perpetrators to prevent the victim from having access to a phone. So that's interesting. Jenny says the audacity of Courtney to not take responsibility for her actions. She seems to have gotten away with a lot in life with her parents being enablers. I saw the videos and broke my heart for Christian. Yeah. Lizolette is asking, how old is Watson in the puppy picture? 14 weeks? No, 18 weeks? Really young. Really young. Jenny says, I've wondered about that. If he couldn't find his phone to call 911 himself, I've wondered if she hid his phone. That might explain the walking around. That's a possibility. Interesting point. You guys are so smart. Addie says the parents did help her. Her parents almost got charged. Actually, her parents did get charged because they tried to break into Christian's laptop. The charges were later dismissed. Thank you for the compliments to Watson. Yeah, he could have been looking for it. Christian could have been looking for his phone. He could have not realized how serious his injury was. We don't know. But we do know there were a couple of places where there was pooling, so we know he remained there for periods of time. So what the heck? What was she doing? Right? So we know it wasn't he fell and she called 911. We know that. The physical evidence says that. Even if you don't want to believe the phone logs, the physical evidence says it. Hungry Ghost says, intelligent chat, in my opinion. Yes, the regulars here are terrific. Jen is asking, are we going to watch the parents' arrest? I don't know. I don't know if it's worth it because we know that the charges were dismissed. So it's kind of over. Addie says she delayed calling the cops, so she may have had his phone. Don't know. We know the phone logs are between her phone and her mother's, though. And she called 911 from her own phone. Oh, my chat got disconnected for some reason. You know what? I think we've been here for a long time. Oh, here we are, reconnected. Oh, Jen is saying the parents' arrest would be interested from a behavior perspective. Yeah, maybe. We'll see if there's time. Okay, so I can do a live tomorrow, but I can't. I have Remembrance Day things I have to go to, so I can't do it till 1 p.m. So I can come back tomorrow at 1 p.m. Hopefully people are available. And I don't know about the rest of the week. I know because I forgot to check my date book before I went live, which was dumb. Anyway, I know that on Wednesday, if there is a hearing, a live hearing on this case, we'll just cover that live. If there's not a live hearing, we will do a live stream. And I think that's at 9 or 9:30. So we'll do something on that day. Okay? So I think I'm going to end it here. Thank you for hanging with me for so long and for all your intelligent comments, and thanks for listening. Trust your gut, and hopefully I'll see you tomorrow.